What's up, everybody? This is Cameron, of course, and this is Operation Wisedome. It's Saturday, June the 21st, 2025. It's crazy. This whole month, every day that we've had a meeting has been on a numerology of 3, 6, or 9, so that's cool. And it's, of course, the 6th month. You already know how I do. And today, we're going to be working with Palmira somewhat, but of course, it will kind of transition. Maybe it'll go full long term for everybody to discuss and see what's going on and see how we can help. Palmira's situation is kind of sticky. She's never been in trouble before. Real sweet girl, pretty as well, but she's just having so many issues. And she's kind of innocent in this, don't know really what's going on. Kind of getting caught up in some family drama that she shouldn't. And she's never been involved in anything like this, and she's learning really quickly. She's been having a dude that's helped her. His name is Sergey, I believe. I don't know how they know each other, but yeah, this has got some ADA violations as well in it. Of course, I'm American Disabilities, or I'm an American with a disability, so it kind of hits home to me a little bit more. I don't know where she's at or what kind of issues she's having. Normally, she can just always join, so I don't know what's going on. Let me check real quick with her. I'll just pause it. I don't want to mess up this recording too much. How do I do that? Pause. Hey, Lana, you looking great out there. See that sun shining on you. So what I want to do is go over real quick before starting up with Palmira and all the situation going on with her. What's up, Jonathan? And get into what happened, I
What's up,
believe,
brother?
last week with Quinton. So if everybody doesn't know, Quinton, of course, is out in Kansas. He went to court again. He did his own thing. Like, I did not help him in this at all, which I think is beautiful because, you know, once you get a certain amount of help, you're supposed to kind of take off and run with this and kind of know and ingrain it and instill it and do your own thing and test out your own methods. And I think that's what's most important, is not always leaning on me, but leaning on yourself, because you know who you are finally. I think things could have maybe gone a little bit better. I think he could have mentioned some things and stood a little bit stronger. But the only thing that, well, I think it's just really interesting that we have other channels and other people now out there continuously trying to find us in any manner to try and call us soft sits. But I find it very odd too that anybody who knows a little bit about their rights and comes in as pro se, pro pro persona, or any aspect whatsoever, um, is called a sovereign citizen, or just put in a derogatory manner. So let's get into this just real quick. It's actually short. It's not that long, and then we'll start getting into today's purpose for the or our topic today, and really into everything that's going on.
Number 2025 TR 12. This is State of Kansas versus Quinton Lawrence Height. It's case number 2025 TR 1215. Quinton Height appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count 1 the charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail, or both. In count 2, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine, or both. What are your intentions regarding a plea here this afternoon, Mr. Height?
Good afternoon. I do not intend to plead.
Why is that, Mr. Height?
I have a few clerical things I'd like to clear up.
Okay, now I'm gonna pause it 1 second, and the reason I'm gonna pause it is because where's the introduction? Where's his introduction? He's not doing any introduction right now whatsoever. Okay, there always needs to be an introduction of how you're coming in, how you're appearing into the court. Okay, when your case is being called upon, you need to make some kind of announcement. Okay, Your Honor, I'm Cameron James Wilson, the living man, appearing specially and not generally by special appearance and not in persona. I stand before this court as a sovereign individual endowed by my creator with unalienable rights that predate and transcend any governmental authority. I do not waive any rights, remedies, or... I stand before this court as a sovereign individual endowed by my Creator with unalienable rights that predate and transcend any governmental authority. I do not waive any rights, remedies, or defenses, whether procedural or substantial, whether at law, in equity, or otherwise. I expressly reserve all rights under UCC 1-308 and the doctrine of sui juris. Before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden-shifting doctrine established in State versus Baroscar in 1989 and State versus Stringer in 1981, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations, which is, what's non-hearsay? What is a hearsay allegation? Can someone name one for me?
By way of
Or it's a statement
information.
made to prove itself.
Thank you. What else? These cops like to write it.
Well, the judges like to say by way of information.
By
we
way
are
of
charging you.
information, police report,
Unsworn
incident report,
affidavits.
unsworn affidavit. Yes, ma'am. Right? Unsworn. So they bring in these damn police reports and these incident reports, and they thinking that that's going to fly. No, we need a non-hearsay allegation, homeboy, within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. This burden-shifting principle derives not merely from procedural rules, but from the natural law principle that no sovereign individual may be deprived of liberty absent rigorous adherence to fundamental principles of justice. Okay?
Is this recording, Cam?
Statement. What's up, Papa?
Are you recording this? I didn't see the record button come back on.
Yeah, we're good. We rolling.
Okay.
Cameron,
sorry.
you know we want a copy of that.
Absolutely.
These are just this. You might as well just screenshot, because if anybody wants any kind of script, y'all already know what's up. How many times have we made scripts together?
I know, but that was worded
Mhm.
real well, dude. That was worded well.
You know what I'm saying?
Also, sometimes they get buried in the feed.
And we
Okay,
don't
well,
see it on the screen anyway.
Okay, well, this is just a jurisdictional challenge for mine, something I would use. Nothing crazy, but if judge asks for a plea, jurisdictional challenge for core arguments, addressing absence of officer, burden shifting argument, creator endowed rights assertion, and then prayer for relief, right? If judge insists on plea despite jurisdictional challenge, again, and then a closing argument, right? So nothing just crazy, but yeah, I guess y'all can have it if y'all want it. Download, and then where's the chat?
Thank you, Cameron.
Y'all welcome. Yeah, for sure, for sure. Where is the chat? Oh, I don't even have my mic on. I'm not even sharing screen. What the hell is going on? My camera's
Yeah.
not showing.
Yeah.
Damn, bro.
Yeah. Good morning, everybody.
Yeah, I know. Good morning. What's up, Ralph?
Grand Rising, everybody.
And Rising, G.
Howdy. Grand Rising.
Let's see where we at. I saved that in this.
We don't want to cry or boo-hoo over anything.
All right, there you go. I threw it in the chat. So there's that for y'all if y'all want that one. But you just remember, you need to make an announcement. Don't come into this thing and say, I am here, I can't make a play, and then plea, and then not make any appearance whatsoever.
Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
Ah, look at his face. Did you see how he just did that? Oh, he didn't like that, bro. Watch
This
it.
guy's
Document
new.
is true, complete, and correct?
Not sure why I'm answering your questions, Mr. Height. We're here on a first appearance on a criminal case.
Criminal case. So, right there, if I hear we're here on a criminal case, okay, if that's true, then where's the corpus delicti? Where's the victim? Where are they? Where are they at?
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Well,
may I
let's
move
move
on?
on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Height. And we'll be establishing another court date.
Practicing law from the bench.
Your Honor, that would not be.
Now, it's actually part of their rules. If you don't enter a plea, it's part of their rules to enter a plea for you or on your behalf as far as not guilty. Just being honest, just throwing it out there.
My
What's really
preference.
fun is
I
then when the
would
chief
like
of
to.
police tries and tells you,
Go ahead, Alira.
when the chief of police tells your judge to write it up as a no contest instead.
Oh wow.
That's
Yeah.
why I wrote under duress and signed it under duress, and then she went back and did a plea correction that day.
Well, yeah, that one's wrong for sure. That ain't gonna work.
Have
Well, I don't
Okay.
care if it's your preference or not.
Thank you. I would like to have.
Well, I don't
a-
care if it's your preference or not.
Thank you. I would like to have
Bias.
a probable cause hearing before a plea
You're not
is heard.
entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that
I
correct?
will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one,
I do comprehend this. Thank you.
but you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be
All
presenting
right,
myself.
very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quinton Height under it pending further proceedings in this case, which I will set.
Dude must be sitting at home in his office.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you
The
for that.
court
I do.
Okay, so right here, why are we okay? This is fine though. He's bringing up certain things, but who do we need to be addressing the burden of providing information from?
Prosecution.
We don't need to be asking this nigga to tell us. We need the prosecutor right here. Nigga, that's your job. Provide proof, not just mere statements on the record. That ain't gonna fly, bro.
Did you
It
not
has
hear the judge
jurisdiction.
tell him that he's not allowed to have a probable cause hearing for a misdemeanor case?
Yeah, and that
Where
may
did
be
that come from?
I don't know, but that may be again some rules within their own. I mean, probable cause. First off, this is the reason why. This dude knows for a fact that Quinton. He probably already knows that Quinton should have never been arrested. Okay, we were just going over this very, very, very heavily last night with them. That's why they got class action lawsuits, because their situation is very, very sticky. Okay. The 24 dash, where is it at? I forget. It's 24 dash something. 24.
.044.
No, it's their KSA.
Yeah, that's what I was
There
saying.
it goes, 22.
24044.
Yeah, this one right here is the biggest thing for Kansas, and why a class action lawsuit is like, man, it's amazing. Like I just can't wait to bring it forth. So this is an arrest by a law enforcement officer. Okay, a law enforcement officer may arrest a person under any of the following circumstances, and only these. Right? Warrant, probable cause, crime, all that good stuff. But then we get down here to D, and it says any crime. So any crime, that means, of course, injury, harm, loss to another, except a traffic infraction or cigarette or tobacco infraction. Not only that, then we have case law over in Kansas from the appellate court that clearly comes forth and brings the aspect that, yeah, you can't arrest people at all in Kansas for a traffic violation, period. Like, not supposed to happen at all. Don't even bring this shit up again. It's already established, and it was like 2020 when they established this. And I don't know, it's somewhere in this notice and demand. I'm not gonna hunt for it forever. But he's not even supposed to be in this courtroom. Now he knows. Now he's not on his coming into his next hearings. He knows this new information, so it's gonna be a lot different as far as how he comes into the situation, how he argues the situation, and how he does not allow the judge to roll over him. But this is a 23-page notice and demand and to dismiss as unconstitutionally applied. We getting big, kind of like Ty. you know, and it just goes into every aspect of everything and how everything that they did is totally illegal and how it has to be dropped. It's actually, they have a duty to drop it. And if they don't drop it, the issues that will happen because they're not dropping it. So it's pretty deep, y'all. You just got to get into the law and use the law against them. So
Doesn't that
think
mean
that's-
that?
I do
Fast, just
have
to
a
put it out there too. I know
What's a-
there's a rule in Texas that a judge has to be in their office when doing electronic court dates. So if he actually is in his house like you think, you might be able to look in Kansas and see if they have a similar rule in Kansas and get that judge penalized for improper court hearings.
well, he
for not
already
being in
wants.
his-
Well, he already wants to recuse, homie. He's like through this ordeal right here.
Yeah.
He's like, he entered a plea on my behalf. I'm like, okay, but that's within their rules that they can do so. And it's like,
Yep.
you know, and first off, and again, that's if everything is valid, right? That means if jurisdiction is truly established properly and everything is done in the right manner. And that's why, you know, I didn't get to finish it, but that's why that jurisdictional script, what is that? This one.
Right. Wouldn't that make sense then to have like a powerful introduction? Judge, I don't belong in this courtroom and this case does not belong in existence, and start from there.
Right on.
Yeah, you can. Yeah, you could.
Yeah. All right.
Everybody's different, Danny. You know that.
Yeah, I know. I'm just loving it,
You're
man.
the design
Yeah.
guy, so you know that in here right now we have people that have never been to court, and we have people that have been into court and have literally like you slap the judge around like they're his little bitch, you know, looking like Siberian tiger out in Portland. You know what I'm talking about? So, I mean, when it comes down to it, it's just all about everybody's level. So I have to be, you know, we have to be cognizant of that, and I know you are. But yeah, this jurisdictional script here, which is the state of Inferno versus Cameron versus Wilson, and yeah, this is official court transcript where we just pulled everything. I think I forget who sent this to me first. I think it was Russ. I think Russell sent it to me first. And it's where it's a video just like AI, and it's so bland. It sounds horrible. So I just turned it into a jurisdictional script itself for everybody to kind of read and understand, you know, how strong you can stay on jurisdiction and how you don't have to get mean. You don't have to get rude. You don't have to be belligerent. You just got to stand on what you know to be true. And never waive that and just keep going and going and going. And if they want to find you in contempt, we'll let them do so because you're doing what you're supposed to do according to the Constitution. It's the same as anything else in this life. So I don't know. Anybody else got some?
Cameron, I just want to say that, you know, that affidavit that you did for me looks similar to what you're showing there. And I'm sure that is a big reason why they dismissed my case. That paperwork was awesome. Thank you for that.
Yeah, you're welcome, bro. No, we try to get on the very, very depths of it. And we're going to be speaking with Palmira, but I think like going through some of that documents and then y'all sharing feedbacks, Sean, Ty, Ralph, Alira, everybody in here that's actually, you know, Joe, Doug, everybody in here already knows what's up. And so I think, you know, Palmira's never been into one of these, so she got no clue. And she's just like, you know, she sees me and we have our meetings, but she don't know, you know, she's like, okay, is Cameron juicing me up? You know, is Cameron just, you know, saying this bullshit? And I get it. Nobody really truly understands the power that they have until you really look and see how for ages upon ages, it's been stated how much power we have. We just lose sight of that. It's all based on knowledge. Oh, my baby girl is tripping. Ooh.
Cam, I'm
have
almost
no
looking
power.
forward. Excuse me.
Unless you
Cam, I'm
I
almost
do,
looking.
Hold
I
on.
did
Go ahead.
I did a territorial jurisdictional challenge in mine, based on, the 10 square miles and, the, Northwest ordinance going all the way back to your 4 organic laws. I sent you an email of what I put into my court case, Cameron.
I was gonna say, Cam, I'm almost looking forward to getting my next traffic ticket.
Doug, you have no idea how. So last night I picked up 2 cases. I actually just put it in the chat. I'm excited about these. My daughter's boyfriend got a traffic ticket, and my son actually got arrested from a traffic ticket yesterday also. So it's about to get real. They got to put in some time. You know, Elijah, last time he ended up just was like, nah, I'm going to pay the ticket. But this time he's going to have to put in the time and work to really, you know, work his way out of this one.
That's how it starts.
Let's go, dude. Let's go.
Yeah,
for
Yeah,
real.
the family, man. That guy's a freaking hero. That's awesome.
Yeah, well, it's gonna be good now. Like, what did he get arrested for? Standing up on his rights?
No. So in Virginia, it's like, I guess if you go over 80 miles an hour, he allegedly, by the way,
All
if
right.
you go over 80 miles an hour, it's an arrestable offense. So
What is it? They bump it up to reckless driving?
probably, yeah. I don't. I get a phone call at 3:30 last night, and he's like, "Hey, Dad, can you come and pick me up? I got arrested." So I haven't even looked at the ticket yet. I woke up just not even that long ago. I'm kind of running on fumes here. So, but yeah, I got some research to do and to figure out what that's all about. But yeah.
Yeah, so if I'm not mistaken, no, it's unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. By failing to hand over citations and prolonging the encounter, they arguably made the stop longer than necessary to effectuate its purpose. So Rodriguez is a very, 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 very strong case. They're supposed to issue the tickets and let you go. They're not supposed to get into just investigating a whole bunch of other stuff and trying to just, they're supposed to issue the ticket and go. That's it. Period. An officer may engage in other inquiries during a traffic stop, such as checking identification, examining registration documents, or verifying the absence of outstanding warrants. See Rodriguez. While an officer need not use the least intrusive means conceivable when executing the function of a traffic stop, the chosen actions must be the least intrusive means reasonably available. Unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. This whole paragraph by this judge is like the best thing ever. Like, give me that, especially with a traffic stop. So yeah, that'll be fun with your son. I know that he's not enjoying it, but what was the reason for arrest?
Filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
So right here, things should have been a little bit different, right? He's stumbling a little bit, don't know what he wants to say. Now, if we're coming into the aspects of they're going to enter a plea on your behalf, well, I had just went through one, but I object, Your Honor, because it falls within legal territory. The charges are filed in this court. You cannot delay the proceedings. This court has jurisdiction and you must enter a plea. He's going to enter a plea. Let's say he enters one on our behalf. Your Honor, I'm not attempting to delay. I'm simply invoking my right to challenge the court's jurisdiction. Jurisdiction is everything. Turning to the prosecutor. Does the prosecutor have any evidence to present jurisdiction? I object, Your Honor. The prosecutor's statements are not evidence. I demand specific factual evidence be placed on the record to prove jurisdiction. The court must establish through admissible evidence that it has jurisdiction over both the subject matter and my person. The prosecutor has presented none. Mr. Wilson, these are standard proceedings. The court has jurisdictional based on the charges and the location of the time, including this information sheet. Your Honor, I again respectfully object. Legal standards cannot replace factual evidence. I challenge the court to provide factual evidence of jurisdiction, as assumptions and standard practices do not fulfill the legal requirement of proof until jurisdiction is established on the record. I do not submit to the court's authority, nor will I enter any plea. You are required to follow the procedures of this court. Do you want to be in contempt? Your Honor, I understand or comprehend, because I don't say understand. However, I am exercising my right to challenge jurisdiction. I have that right. And I also request that this court acknowledge that no plea can be entered until jurisdiction is proven. I reserve all rights and rebut all presumptions that this court has jurisdiction unless it is established on the record. We believe the defendant is attempting to delay the case. I object, Your Honor. I'm not attempting to delay anything. You see what I'm saying? So you can stay hardcore on this without getting frustrated or flustered or belligerent in any manner. And just stay strong. Like, hey, this is the element that has to be met first. Like, I'm not proceeding. Y'all not finna just force me into this. We can go
What
back.
are some of the aspects that make it not a fact that he was in the county on that road? That's what the judge said. Oh, well, you were in the county and our officer saw you, or something like that. So now that's a fact to them. Why is it not a fact to us?
Well, first off, let's look at the court element. Okay.
Yep.
The court element is that they've brought forth an allegation, but it's hearsay, right?
Well, so far the judge is only dealing with an allegation that any
all
reasonable.
hearsay.
Well, no, the allegation wasn't full. Oh, I guess it is because that cop's not there.
It's hearsay. Just the incident report itself is hearsay.
It's true. I get that part. It's just that they consider a factual part in the county, on the road, driving.
And
so
they're using some kind of imaginary system of roads and without any kind of proof.
Which I think is the admissibility of it. I think the fact that, which isn't admissible because you don't have standing to bring the case. I think that's what makes it not factual, along with each time it is hearsay because the living man or woman is not there to testify to the veracity of it.
Exactly.
I get that part. I get that one, but I think it's not admissible. What is it that makes it not a fact? It's hard to say that's not a fact when it's like the county,
because
the road.
Where's the evidence to prove that allegation?
There's nobody behind it making an affirmation.
The state assumes to own the roads, though. That's
no one has. Okay, there's another element. No one has. Where's the affirmation under penalty of perjury? Where is it signed? Where is that?
Did the cop sign the ticket?
But is it under penalty of perjury?
Is it under the? By the way, you can insist on penalty.
When a cop signs the ticket, he's not making an affirmation. He's just signing it as his title.
As his title. That can't be an affirmation. That's signed as a title. Affirmations are only made by men and women.
Who aren't title of nobility.
Right.
So there's three aspects. Hearsay. Hey. Another aspect is, sorry, go ahead, what?
I was saying, I asked you a question. Aren't title of nobilities illegal as well?
Totally.
If I might.
Yes, please.
100% they are.
The couple of issues are come to mind here. One, who's made the complaint? Okay, is it just a cop's ticket, or did the people actually make a complaint?
Exactly, it's the agency.
No, it has to be the DA has to actually make a complaint. He's the people's attorney. If he didn't make a complaint, what are you doing in court in the first place?
Exactly, that's the whole point of the corpus delicti, and that's why I say it's the agency.
A cop can't issue a complaint. It's not his purview. It has to be the DA. If the DA didn't make a complaint, there's nothing to be done.
Well, you take it back even one step before the complaint. There has to be a verified victim to bring forth anything.
That's just another.
Just do what they're doing, which is where we've gotten to. We've gotten so far along where now they're just out here blanketly just issuing tickets when they see anything. When first off, it's supposed to be if someone is offended in any manner, not as a control mechanism beforehand. This isn't what if land.
But the ticket by itself is not what gets that can't get you into court. It's a notice to appear, and that's about all you got.
Isn't it a conflict of interest?
No, because he can't summon you into court. That has to come from the DA.
No, I'm saying the cop issuing the ticket in and of itself, isn't it a conflict of interest?
Well, the conflict of interest comes up when you have three parties in the court. You've got the judge, you, and the attorney, and the cop. There's four, and three of those guys work for the same outfit. So you've got the judge and the jury. Now, the judge is the jury, and the judge is beholden to the party on the other side. That's a conflict of interest.
True.
Okay, so the state can't judge its own case, is what I'm trying to say. And they talk about that in the Federalist Papers. And John Jay even makes a statement about that in one of the cases somewhere. And he was the first chief judge. So,
Oh, yes, he does. Absolutely.
and
If
so
I may,
there's all kinds of conflicts of
before-
interest going on here. But the bottom line here is if the DA did not write a complaint, there's no business for you to be in court.
he was talking about the Federalist Papers number 10 and Federalist Papers number 80.
That's the ones, yeah. But that's the thing. If there's no complaint, why are you even in court? And the person that has to write that complaint is the DA. I'm done. I'm good right now. Go ahead.
Good job, Papa. Thank you.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint.
Why did the judge just smirk like that? Like, it's a real thing, bro. Like, what?
Go back a second.
Watch this judge. He just smirked like, what are you talking
That
about?
judge is on
Additionally,
one
I'd
hell of a
like to
power struggle.
let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in
He's letting him
that
interrupt.
is in regards to the case filing.
Homie didn't file anything.
Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
And this is the arraignment hearing. So you see how he read that, but he read it wrong. You see what I'm saying? Like, if you're going to read, make sure you're reading things right or be right on the spot. Like, at least read ahead to know, oh, I got to change that, right? I got to say something different there. Be ahead of yourself. Don't just read from the script. Actually be prepared, or these minor mistakes will cost you. That's a minor mistake that kind of is costly. They're like, oh, look, he reading from a script.
Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing?
Now, it's before the arraignment hearing ends. I would have quickly said before the arraignment hearing ends. Is it, even if I mess it up, I'm still going to finish it right.
Begins.
He's flustered.
Court's going to assign the case to this division.
He moved on. And I would have interrupted. I would say, object before moving on. I did just ask a question. Are you going to repeated that again before this arraignment hearing ends? And recorrected myself.
I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date.
Idiot.
I'm going to set the hearing time at 3:00 p.m.
Pause that. Did he just say for your first appearance?
Yeah, he was going to say first appearance again. And he was going to name a specific judge, but he didn't name that judge. He just stopped himself.
I just couldn't tell from his words if he was saying, okay, we won't call this an appearance. And so you'll have a first appearance again.
Well, I don't know.
I don't know. Back up 2 seconds. Well, if you don't mind.
Yeah, that's fine.
I haven't even been arraigned yet in my case since 2000 or January 11th.
I'm going to set the hearing time at 3:00 p.m.
Oh, it's even before this.
In the case, Mr. Height. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date.
Yeah, so he's about to say with somebody.
Okay, yeah, no.
I'm going to set the hearing time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock, Monday, August 25,
Is-
for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
I wonder
Okay.
why.
We'll conduct the next appearance by Zoom.
Okay.
Wow.
Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll
Okay.
be participating by Zoom, but you can participate from the Judicial Center. So make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3 o'clock, he's going to represent himself. And the court
And-
has approved and maintained him under his previously established bond of
Right there, there's calling jurisdiction. You hear that? You hear he's calling jurisdiction?
Dude, back it
He's
up.
gonna represent himself.
And
Say
why?
a couple things,
And
bunch
yeah,
of
there's
things.
quite a few things.
Monday, August 25, 3 o'clock. He's going to represent himself. And the court
And-
has approved and maintained him under his previously established bond of
There it is.
$2,000 cash.
Yep.
Man, oh, that was brutal.
Yeah, well, they're trying to.
George
trying
acting
to
like he
bring-
got a claim against Quinton.
For real.
Am I missing something? Maybe I'm not hearing it. What are you talking about, Dan? What was it?
Well,
The
just that
words
moment.
that are being used
Yeah.
are claiming jurisdiction over Quinton in such a manner that I could not reply to.
In the next hearing.
Hardcore.
So Monday, August 25, 3 o'clock. He's going to represent himself.
Right here.
And the court
And-
has approved and maintained him under his previously established bond.
Proved and maintained him. Oh, I ain't getting maintained, bruh.
Of $2,000 cash.
May I also ask what
Okay,
judge
just a
and
minute,
what
I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quinton Height at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order, stay if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has,
No, for the judicial economy. Can we go ahead and address those today? Judicial economy. No.
No.
No, I don't wanna. You see, so we know this dude here. He's just he no way no.
Tell the court that
I
there
wanna
does
know
appear
who
to be
that
another
Michael
case
Mc-
involving this same
Pearson person is.
Oh, he's just another person appearing.
defendant.
Okay. I don't like
where
the
it would
comments he
appear that
keeps
an
throwing
appearance
up
bond
either.
has been executed for at the end of next month. I'm not sure, given the court's order, stay if the court wishes to address that matter at this time for the purposes of the judicial economy.
no. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of
There specifically seems to be a bond. Peabody.
$1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course, you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3 o'clock, Mr. Height. I
Thank you
think
for-
that concludes our business on
I have
your
one
case at this
further
time.
One for
Our business. Your Honor, I'm not conducting any business here today. I'm standing before this court, appearing specially and generally. Yeah, but I'll be going in. What?
question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
In about 6 days, too.
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case. Okay.
Thank you for clarifying.
And if there's nothing further, The Quinton Height matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
He totally gave him jurisdiction.
But he wasn't ready.
You can take it back.
Yeah, he can challenge it again.
Totally take it back.
Yeah, so it's okay.
Yeah, you can challenge jurisdiction at any time throughout any of the proceedings.
Yep, and there's a lot more time he's got until August. You know, he's got almost 2 months. You dig? So homeboy is he's got some work to do, but I've been working with him pretty heavily, and last night we was working together pretty cool. So he knows what's going down. But that's homeboy. That's what's been going on with Quinton. So I just wanted to share that one. Palmira, what's up? You got to unmute.
Well, real fast too.
Hi.
He could do a plea correction if he wanted to, because he did say it was under threat or under duress that he was allowing it.
Yeah, he can go back into that jurisdictional script and hit pretty hard on several aspects. Hi, Palmira. Everybody say hi to Palmira.
Hello, Miss Palmira.
Hi,
Palmira.
Love you, Palmira.
How are ya?
Thank you.
Yeah, so
Okay.
Palmira's got a pretty crazy situation. I think we've been working together for about 2 weeks now. And kind of interesting because she don't know anything and she just like so scared, I can tell. But it's been traumatic for her too. So I be forgetting because I just been through so many traumatic things. I kind of have been calloused up a little bit. So other people, for them, it's like, oh my God, does this really happen? It's like, yeah, man, you what? You want to see how bad it gets? Let me tell you a story or two. You know, I've run over a cop in my life. It's like, what? Like shit is crazy. So, yeah, and that's real talk. It's not a joke, y'all. It's really happened. So, yeah, anyways, with her situation, it's just very weird. She's been caught up in a whole bunch of like, I guess like family issues. Palmira, you want to kind of tell your situation so people know what's going on?
Sure.
Okay.
So I was at work and my brother's neighbor calls me that his girlfriend put a warrant for his arrest or a report, and he turned himself in to see to deal with that. But then now I had to go bail him out. I go bail him out, and they don't allow him to leave because his girlfriend requested an ankle monitor. So he just tells me they won't allow me to leave even though you paid my bail. So just ask for my keys, my car keys, drop off my car to my house and sleep over my house, so you can feed my pets and just stay there. Collect all my documents that I had been working on that are on my dinner table, and my gun that is on the bench, and put it all in this backpack and just stay there at the house. And okay, so I go do that. I arrive at the house. Like 2 minutes later, his girlfriend arrives, her friends arrive, and the sheriffs arrive along with them. So I go in the house. I'm quickly trying to put all the documents and all the stuff he told me to put in his backpack. I do not go through anything. I just put him in there, and all the sheriffs and his girlfriend are knocking on the doors and on the windows of all entrances of the house. And so my brother calls me again from the detention center, and he says, "What's going on?" I said, "Well, everything is in the backpack, but the sheriffs are knocking on all the entrances, and your girlfriend's with them, and her friends are with them, and they're knocking pretty hard, and demanding that I go outside to let her in and grab some stuff." But I don't want to open the door. I just want to stay in here. And I know that I don't have to open the door. It's my right to just stay here. And if she has
Yep.
keys, she could just come inside, right? And he
Yep.
goes, "Well, she should have her keys." She used to live there, but it had been like a week that she had been gone. So it sounds like they're gonna break the window. So I just
No, they're not. Almost
um,
certainly not. They did
so
that to me. They
I
did that to
started
me
getting
every window.
Yeah, so I started getting nervous, and so my brother hears that in my voice. So he says, "Look, I don't want them to hurt you physically or anything, so just open the door, put the backpack on yourself, and just don't leave. Just stay there. Just let them do their thing." So I do. I open the door. And I tell the sheriff, "I'm just gonna be in my car while you allow this woman to go in there and grab her stuff. He's cool with it. I walk past the sheriff, but as I'm walking past the girlfriend, she throws herself at me, tries to remove the backpacks from my body, so I just retrieve them, and she goes hysterical. So the sheriffs have to grab her and to keep her off of me. So I just continue walking towards my car. I go in my car, but by the time it takes me a little bit to get in the car because I have a fused hip. And so by the time I go in my car, they already had the other doors of my car open because she started screaming, arrest her, search her. She has my stuff in the backpack. So I just replied, no, this is my brother's stuff. And then I'm in the driver's seat of my car, which my car had been blocked by the sheriff's patrol car and her friend's car. So my car was parked in my brother's driveway. So I was definitely not going anywhere, never turned the car on or anything. So they opened all the doors, and then the only door that was closed in my car was the driver's where I was sitting. And so the sheriff's like, get out of the car, get out of the car. I'm going to arrest you. Again, intimidating me. So I'm like, why? The whole time, like, why are you going to arrest me? What did I do? Just get out of the car. So I get out of the car. They quickly handcuff me, and they're telling me you're being detained for obstructing this investigation or something. And I'm like super confused the whole time, and they're removing all my personal belongings from my body, my wallet. They couldn't get my wallet off of my jeans because I used a clip to clip it in there, and they're like, can you help us take it off? And I'm like, well, I'm handcuffed. I can't. And so they finally get it off, and the guy's like, the sheriff is pulling me towards the patrol car, and the whole time I'm telling him, hold on, I need to tell you something. And he's like, no, stop resisting. And he continues pulling me forward towards his patrol car. And I'm like, no, I can't walk that fast. I need to tell you that I have a condition. But he continues to interrupt me, saying, you're just resisting and obstructing. And so I'm like, I can't walk fast. I need to tell you that I need my hands to get into my car. But he doesn't let me finish my sentences. So he just forces me into his patrol car. But when I sit, my fused hip leg goes, it stretches forward. Like I have no flexibility on my left hip. So I need space to stretch my leg. And I'm freaking out because I look into the car and in the patrol car, and the space in there is very limited. So I'm freaking out. I'm like, I can't go in there. Like there's no space
Can I
for
ask
my
a
limb.
question?
Yes.
Do you have disability plates on your vehicle?
No, I do not.
Do you have a handicap placard?
No,
That's irrelevant. The moment she's trying to give them notice and they continuously ignore is enough. Like,
Yeah,
remember, you're the highest of authority. You don't need nothing, no permission from nobody. If you start telling somebody, bro, you a creation of the creator, that's it. It's a verbal notice. They're intentionally, and even if that was the case, it don't matter if it's intentional or not. Like, they are required to know the process, bro, of how this goes. If they don't know the process, they will be held responsible, bro. That's how this goes.
That's definitely an ADA violation.
It's big time ADA violation. Like, what you talking
it
about?
is too. And you
Like,
don't have to have the placards to be considered an ADA
at all.
violation. That's privacy. To require you to have a placard to prove that you're disabled is a violation of HIPAA and your privacy rights of your medical information. So trying to use
Officers,
that as a fallback is also wrong.
yeah, not gonna happen either. The officers of the law and the execution of the process, what process? The law, are required to know the requirements of the law. And if they mistake them, whether through ignorance or design, whether they didn't know or on purpose, and anyone is harmed by their error, which Palmira was, they must, not shall or can, but must respond in damages. It's very clear. Not hard to understand at all. Must. This isn't no if, ands, or buts. All right, keep going, Palmira. So
So
you're
they
freaking out. You're
charged
looking
me,
at it. You're like, no, keep it going, because you was being in detail, which is good for everybody. Because they getting
they
them.
charged me with
Wait,
resisting arrest.
wait. You was at
Sorry.
the point where you was at you was looking at the
She was
door.
freaking
All
out
right.
about not fitting in
Freaking
the
out.
car.
Yeah, go from there.
Okay, so so I'm like, I'm not going in there. But in my head, I know it's because of the limited space that I see in there. And so he's like, stop resisting. So he grabs me from my arms and he left bruises on my arms. Because I was like, no, I can't go in there. And so he's like, stop resisting. And he forces me into the car. So my leg stretches out. And so half of my, like part of my foot is out of the door. So he keeps trying to close the door on it, telling me, stop resisting arrest, put your leg inside the car. And I finally said, I can't. So he grabs it and bends it in ways my leg doesn't bend. So he forced it to bend and he closed the door and locked me in there. So while I'm in there, he walks towards my brother's girlfriend. He starts taking everything out of the backpacks, giving her stuff. I guess there was one advertisement mail addressed to her. So he charged me with larceny of mail with the amount of $1 or for the amount of $1. And then my brother had two guns in there, and I put one in there that I knew of. They're all registered guns to him, but one was missing. So I guess so that what I witnessed from the car is that the sheriffs and the girlfriend and her friends like got together in like a group. I don't know what they said to each other, but right after that, the sheriffs walk into the house, and the girlfriend and some of her friends go through my car, and I don't know what they're doing in there. I just see them going through my car. I guess the backpacks, because now we know that some of the keys are missing. One of the guns that was in there is missing. And so then the sheriff comes back into the car and asks for my name, and I just stay quiet. And he goes, if I bring you your wallet, which I put in your car, could you open it for me? And I said, yes, if you remove the handcuffs, I can open it for you. So then he just goes back into my car, and I see him open my wallet, grab the information, and then he never brought me my wallet. So I told him, hey, you asked me for permission to open my wallet. I didn't give you permission to open it yourself. He just ignored me. And then he says, you're being arrested. And I said, for what? He says, you're being charged with concealed weapon. You're being charged with resisting arrest and with larceny. So I'm freaking out at that point. I'm like, why? And there's many more details. I mean, it was very traumatic. My my brother's girlfriend friends are like just laughing at me at that point. Like I could see them laughing at me. I could the whole time I'm like, why officer, I'm calling him into the car like, what's going on? Why are these people going into my car? Why are you allowing this? Nobody's listening. I'm being ignored the whole time. I asked them, can you please let me out of the car, the patrol car? I need to stand up straight. I need to stretch my back. I can't be in here like this. Because I couldn't sit because there was no space to accommodate my leg. So I'm like, sideways kind of in the patrol car. So with my hands handcuffed on the back of my back. So I asked him, can you please let me stand? Please let me stand outside. I just need to stretch. Just let me be outside. I will just stand. I will not do anything. He's like, no, I can only allow you to put I'll switch the handcuffs to the front of your body. So I said, okay. So he lets me out of the patrol car just to switch my handcuffs to the front, and he tightens them more. He left bruises on my hands and my wrists too because they were very tight. So then they arrest me. He takes me to the detention center, and yeah, they let me out on a promise to appear to court. My brother's girlfriend, the next day I try to press charges for
Oh wait, how long was you in jail?
just hours, I don't know, 4 or 5 hours. Then
Okay.
they release me.
Okay, so they didn't like
That's long
make
enough
you.
to get booked in.
Okay, good. They didn't make you change clothes and do all that crazy stuff. Okay,
No,
that's good.
I wonder
the
why the
whole time.
appearance bond. I mean, that is strange that they don't get any money in that. It's like it's almost as if she's just secondary. I don't know.
It's
The sheriff,
harassment.
It's almost as
admitted,
if they know that this is all wrong and made up and shouldn't be doing this.
yes, the sheriff admitted to me before he took me to the detention center that it was because that he was arresting me because I made him wait to open the door of the house.
Oh, well,
And
if that's on body
that
cam, that's
he
cool.
said, you don't make
I want
sheriffs
that body
wait.
cam.
Oh,
Yeah.
you
They
don't make.
arrested you for a money
Wait,
grab.
holy shit, yo! If he said you don't make sheriffs wait, oh, that's prime time. That sets the whole tone. The whole
This
I
is
said,
good.
yeah, that's
I
great.
told him, I know you're arresting me. I pissed you off because I asked you for a few minutes to open the door. And he
You
said,
know,
yes, you don't make sheriffs wait.
oh, that's perfect. So that just means literally that
How
me.
long has it been since you were arrested and you signed that notice to get out?
Okay, so Ralph, kind of just like wait, and then so
Okay,
yeah, is just say may I or something, then I can stop talking and we don't run over each other. Um,
I'm sorry.
no, it's all good. Uh, yeah, it's just very interesting because if that's what his intent was to say that you're not, you don't make sheriffs wait, then you can literally bring it fruit of the poisonous tree all the way back to when they were knocking on the door in the first place, thereby giving them no jurisdiction and then the rest of it being null and void, like they can't use anything because your intent from the very forefront was just to intimidate, to bring forth threats as though you were going to bust down the door, even though you didn't have a warrant. So that in and of itself was intimidation. Yeah, it's like all void amnesia. It's very interesting. All right, what else you got, Palmira?
Um, well, the next day, my brother was released. I picked him up. We go straight to the sheriff's office. We try to press charges on the girlfriend and her friends for the missing gun that he had in his backpack, some keys. They took his car keys and other truck keys. And so the sheriff listens to us, but he says, you cannot press charges because there were sheriffs present at the um, at the scene. And I said, well, I want to press charges for her assaulting me. You can because there were sheriffs present at the scene. So they don't allow us to press charges for anything. And so everything's very confusing. We leave and we just don't know what's going on really. Um, yeah, so they just put into evidence two of the guns because obviously one was missing, and they allowed them to go through my car. And I did say that to the sheriff. I said the sheriff deputy allowed her and her friends to go through my car, and I want to press charges for that. Oh no, you can't because the sheriffs were present. I couldn't press charges for anything. So I put a restriction order against her, and then right after she put one against me. For what? I don't know. Everything was obviously made up because I've never done anything to her, and I didn't defend myself when she attacked me in front of the sheriffs either. So I didn't know what. Anyway, we go to court for that one. I submit my affidavit of facts, and her lawyer approaches me before the judge calls me to speak on my case. And her lawyer says, well, she says, if you drop yours, she'll drop hers. So I said, yeah, let's just do that. So that one was that. On that day, they arrested my brother, and my brother hired a lawyer to represent both of us. I never signed anything for this lawyer. My brother did pay him. I did go to his office initially with my brother to explain everything that had happened. But the lawyer never gave me a paper or anything to sign saying that I gave him authorization to represent me. So after that court date on May 14, that I witnessed that I dropped the restriction order and she dropped hers, and then I witnessed them arrest my brother, I approached the lawyer and I said, why did you allow them to arrest my brother? You said everything was gonna be okay. So he's like, oh, I don't know, I can't tell you. He's like, but I can tell you that your court is going to meet, I'm gonna make a deal with the DA so they can change your DA, because this DA has it against you. He really wants to get you. And your court is going to be changed from May 20th to May 27th. And I'm going to make it happen that they move it to this court in Pittsboro, which is the bigger town where the sheriffs are located. But so the next day I go to the court and I ask for all my files and certified copies of all the record on file for me. And they say, oh, there's nothing. And I said, well, I know that the lawyer made a deal with the DA. I want proof of that, and that my court has been changed, court date and location. And the clerk says, I don't have any of that on the record. The only thing on the record is that your court is in Siler City and it's on June 24th. So the information that the lawyer gave me the day before that was wrong. So I called the lawyer and I say, hey, the paper that the clerk gave me says I have an e-warrant and I have a court date in Siler City for June 24th. He's like, no, you don't have a warrant, don't worry. So I'm like super displeased with this lawyer. I asked my brother to please fire him. My brother's so scared for me that he doesn't fire him. So I just recently fired him. Like I put in I filed a notice of what is this
Notice of
called?
appearance.
Withdrawal of counsel. And the lawyer is like super pissed off about that, but he finally agreed and he filed his own his withdrawal of counsel as well. But he's like trying to rebut every point I wrote there for the reasons I was firing him. He says, you met with me at my office, so that gives me you know, like there was an agreement between you and I. Anyway, so I fired him. I go to the court clerk and I tell them I want to file this notice of withdrawal of counsel. I will be presenting myself from now on. And I send one to the DA. I also served them one in person. I also mailed it to them. So that's where I'm at right now. And now my brother called me yesterday telling me, oh, the lawyer called me that they moved my court to Siler City. It's gonna be in the same courtroom as yours. And so what they're trying to do is link our cases for some reason. I don't understand that part. It's very like complex.
Well, don't look at it too complex. Don't make it too complex on yourself. They're just moving them to judges that can actually handle the situation. Apparently, they're moving it up to a better court system. You're already bringing up constitutional aspects. Maybe it plays out in your favor. But the situation currently has all kinds of defects on the front end, which are those violations of creator and endowed rights. And so when you have so many of those on the front end like you currently have, those got to be addressed first, and that's what we're trying to achieve to get to. And if we have aspects where they move on without talking about those as we've brought them up and have hearings in relation to those topics as far as documentation being brought forth, then there's issues. But if we're calling a hearing and then addressing those issues and with sufficient time to do such, right? Like the court's actually giving us the time and you're requesting, hey, this may, we may need an hour to kind of go through the topics that I need to bring forth in relation to the documents that's been filed into the record. So when you're looking at it in the aspect of saying, well, what can I do and how do I argue it? It's all about preparing yourself to really mention that there can be no constitutional violations that are out and still proceed with the case. That's not how this works. Their shit don't come above ours. We're up here.
Mm-hmm.
You have to address what's up here first. If all of this is in line, what's at the very top, then we can come down here and talk about statutory. But this up here has to be right. And literally like 90% of the time, this ain't right.
Yeah.
Now
I
with
did
crime, I
even-
get it, but go ahead.
Like when they arrested my brother at his hearing, they did not give him an opportunity to speak. They just said you're gonna be placed under arrest, and then they arrested him, and then he had a hearing while being arrested in the detention center, and it was like an online hearing, like the one we just watched.
Well, Sean says jurisdiction first, don't argue the facts, and that's true. But in relation to speaking on the facts, it is good to bring in the constitutional violations, right? Because if you're bringing it forth through your affidavit and you're pleading, those constitutional violations override anything. That's why, like, through a pleading, yeah, we do have things as far as their violations, but the constitutional violations are on the forefront. It's a hey, this is what happened first, and y'all know if there's anything here that's messed up in relation to those amendments, those foundations, then we can't talk about anything else. And see, like, that's what Quinton's not understanding. Yeah, y'all can challenge jurisdiction and all this, and that's cool too. But now it's to the point like this must be dismissed due to the constitutional violations on the forefront. It's a ministerial duty for you to. You can't just ignore it. Like, I'm bringing it forth. And if y'all just going to ignore it, then I got to take it up somewhere where they're not going to ignore it.
Yes.
Like, that's how it goes, y'all. It's not very hard to move it up. You just move it up. I keep saying this. It's like we all scared to move it up for some reason. Move it up. There's no reason not
If
to
I
move
may.
it up. Yeah, go ahead, Papa.
That is the state named the party?
I'm sorry. Can you please repeat?
Palmira is the state named the party. Is it
Yes.
state of versus Palmira?
Yes. State
So
of North
Article 3,
Carolina.
Article 3, paragraph 2, Article 3, Section 2, paragraph 3, when the state is named the party, the Supreme Court has original jurisdiction. That means your case must originate in the Supreme Court.
Article
Mine's
3,
think alike. I just posted that in the chat. That's
yeah,
so funny.
it's Article 3, Section 2, Clause 2.
Mhm.
Thank you.
Thank you. Yes, I see it now.
So the lower court does not have the jurisdiction.
Yeah, I'm just sharing
So
it
I
again
will
too.
challenge jurisdiction.
Yeah, so if you're copying that, it's like, well,
Mhm.
what are we doing in relation to that, right? How are we going to bring that forth? How would you bring it forth, Doug? How would you bring it forth, Alira?
As soon as they say the state is named the party or at any time, challenge the jurisdiction of this court for original jurisdiction. And it must be transferred.
Okay. And that's if they allow me to speak, right? Because if they just say, oh, you're under arrest, like
Right.
they did to my brother.
A judge who refuses to make a ruling based on both sides, they refuse to hear one of the sides in a issue, they're in violation of a maxim of law and are considered an unjust judge. And you can hold them accountable for that. You can do judicial complaints against them for violating the judicial canons and everything.
Okay. Take note of that. Thank you.
Yeah, maxims of law are a really good thing to look up and have knowledge on.
So Alira's, so Palmira's been saying a lot. What kind of advice do y'all have for her? What are y'all hearing? What do y'all think?
Definitely civil rights violations. Where's the warrant at the start of all this? What, this was completely wrong. If definitely conspiracy as well. The, the way the cops are there with her, the ex, I mean, and the way they're doing things like that, that just seems like she knows someone and is conspiring somewhere to make these things happen, and it is completely wrong in my opinion. It
Yes.
sounds disgusting.
Can I add something?
Yes.
I'm in North Carolina. I looked up the judge's bonds and I found out that the judge who had me arrested had not signed, I'm sorry, not bonds, but oath of office. So the judge that had me arrested had not signed an oath of office since 2019. Yeah. So you might want to look up the oath of office in North Carolina. They just don't care about that. The other thing is when I went to get records, they didn't want to give it to me at the court. They told me to go to the police. The police told me to go to the DMV. The DMV said go to the court. You're having the same thing?
Mm-hmm.
Okay, so I finally discovered a few days ago that there is a docket history. Do you know what a docket history is?
I know what a docket is, so I.
Okay, well, here they said there is no docket. When everybody around me was walking up to the window and saying, I want the docket for this or that, the girl in my window says, well, there is no docket. There is no docket history. So I had to stand there and keep saying it different ways for over half an hour. I think it was about an hour before I finally got to a supervisor that would give it to me. But it is basically who entered what on the record. Was it the judge? Was it the attorney? Was it, what was it with the court? But it's basically the history of everything submitted to the file. And then what I did is I got a certified record of my driving record, which I did not have a driving record because I wasn't registered and I'm not a U.S. citizen. So when I started getting certified copies of different records from different people, and then you go to the police records, and I found out I got a different record from everybody. The police had one thing, the court had another thing, the DMV had another thing, and each of them say, as you're going through getting records, if you ask why is this record different than the other one, they'll each blame it on somebody else. So if you can get a copy of the entries that were made, then you can see what records you should be able to get, because I was not able to get my January 5th. I don't know what you call it. If you call it a charging instrument, the ticket from January 5th where the officer stopped me and impounded my car. He didn't give me a citation. He didn't give me a warrant. They just took my car and the
Yeah,
tow
well, see,
company.
that's right here out of subsection 15A-401, which is arrest by law enforcement officer. An arrest by an officer pursuant to a warrant in possession, warrant not in possession. An officer who has knowledge that a warrant for an arrest has been issued and has not been executed, but who does not have a warrant in his possession, may arrest the person named therein at the time. Arrest by an officer without a warrant. Offense in the presence of officer. An officer may arrest a person without a warrant when the officer has probable cause to believe has committed a criminal offense. Well, Palmira didn't commit a criminal offense. Criminal has crime, meaning someone has been harmed by her actions. No one was harmed by her actions. She was sitting on private property the whole time.
Yes.
They talking about. Nobody was harmed. They intruded her rights and then brought forth their own claims and charges that are non-existent and void ab initio. Like, I'm not trying to talk about anything else but exactly the situation as it is. Like, they violating their own subsections right here. They're in total violation of subsection 15A-401. Okay.
Yes.
And then with that process of violating this subsection alone, which there's plenty more. I mean, most definitely there's plenty more. Arrest without a warrant. What is this one? It's a total different one here. So again, this one probably going to be another violation. Subsection 15A-734. Arrest without a warrant. The arrest of a person may be lawfully made, okay, by any peace officer or a private person without a warrant upon reasonable information that the accused stands charged in the courts of a state with a crime punishable by death or imprisonment for a term exceeding 1 year. Well, we know that the larceny was an accident. We know that especially if it's just an advertisement thing, we also know that the guns were not necessarily concealed out in the public, but within her own private property backpack on private property. So what I'm trying to figure out is how y'all gonna give any kind of concealed carry charges on your own private property when you just simply trying to put your private property into the trunk of your car? Like, that makes no sense to me. Like, if someone told you to grab their stuff,
Yeah, man.
to put it, hold on, and to put it in the back of the trunk, what does that mean? What is it? What's that got going? I don't even. Y'all tell me what I'm tripping on here. What am I making a mistake?
You're
One
not-
time, I was arrested. As soon as you step out the door, you're in the curtilage now, and between the house and the vehicle, with it being in the backpack, yeah, they possibly could do that.
No,
No,
it's,
they cannot. If you're taking on your
No.
own private property, into your car to put away and store and to take off, it's not concealed. You're not concealing nothing. You on your own private property. Once you go out into the public and you concealing it in the public, out in public, that's different, bro. And the conceal aspect has to be like loaded and in your presence and easily reachable and obtainable to use. There's so many elements that go in relation to that. Then what we also got going on, well, that's different, but yeah, no, bro. You can have that's private property, my G.
Yeah.
I don't know what you're talking
no.
about.
If I may.
You're not missing anything, Cam. You're not, because you're exactly right. She even said she was parked in the driveway. The driveway is a part of the private property. So she never once was intending to take that on her person off of the private property. She was intending to put it in her trunk and take it elsewhere, probably back to her private property too, where she was going to have it concealed away too, in private property. It is nothing for them to have had hassle over. It's only because of some word of mouth accusation that came from a crazy ex-girlfriend that has caused this. And that's why I say that she has to know someone in the police or something to have those cops backing her like that by just making a claim. You're in your brother's house and she's going to accuse you of stealing her stuff. Are you kidding me?
Right.
You were there before they ever arrived. You were just there because you were going on behalf of your brother to help him out. There is nothing wrong. You had permission to at least be on the property. Where was her permission? If she had left over a week ago and moved out, where was her permission to be on the property and come do this? Why is she waiting until he's already in jail to get her buddies, the cops, to come with her to hassle this? Why didn't she do this at any other time before this point?
Yeah.
And we're missing the point of the warrant to go in the bag in the first place.
Or the warrant to come in the house to get her stuff.
Even before that, it's the poisonous tree thing. It's the fruit from the poisonous tree. That's what Cam is getting at. Everything after that is irrelevant. It really is. And that's where we need to focus. And I appreciate listening to everybody's circumstances, given that we need to start at the base, at the root problem.
Yep.
Thank you.
There's no standing for them to be there doing what they did in the first place. Where was the warrant for even them to be there at the start to even be getting stuff from the house?
So let me
They
ask,
have a warrant
y'all
to
putting
pick
your
up stuff with her.
Now that you know more about Palmira's situation, what would be the approach coming into a first appearance? I've had this lawyer, she's had this lawyer on her. She's finally getting rid of this lawyer. He's a little bit upset. She's saying the town's a little bit crooked, not wanting to do things proper. She's got ADA violations. She knows she's in the right. How would you approach it? Of course, you're not fearing anything. I wouldn't be fearing or having any intimidation tactics even faze me whatsoever, knowing the egregious ADA violations, knowing that the video is going to be relevant and there's going to be enough of it to show the violations. Just on the constitutional level, we're not even talking about life, liberty, and happiness at this point, or statutory, or even ADA violations. So there's so many violations on the forefront that it makes everything null and void. So we don't worry, right? The worry should be gone. but give some suggestions on maybe how you would approach it going into the courts now that, from your perspective, anybody's perspective, on how you would approach this in North Carolina.
Could she not
Definitely
just
the most.
file a 1983 civil rights violation charges against the cops?
Oh, that'll be coming too, but for the case itself that she's dealing with, that definitely needs a
Standing.
motion to dismiss or a notice and demand to dismiss because it is completely unlawful. There's no jurisdiction. There is no harm. There is nothing that even leads to the elements of what she is accused of.
Yeah, I'd challenge the lead up to the arrest and see if
The
any of the.
jurisdiction.
Yep.
Should I?
Okay, so whoever's just put that in the chat, that's very nice of you to do, Troy. That was beautiful. Troy just gave us a magistrate's order for fugitive. Okay, and as you can see, it's a fugitive. And right here it says State of North Carolina and the county. This is a form that they use. It's of 2023 Administrative Office of the Courts. And it states, I, the undersigned, find that the defendant named above has been arrested without a warrant and the defendant's detention is justified because the crime named above is punishable by death or imprisonment for a term exceeding 1 year, and there is probable cause to believe that on. Now, the only reason that they was able to even do this is the, I would say, concealed carry charges that they falsified and brought forth. Me personally.
And the larceny.
Yeah, that larceny is pretty extravagant as well. I would think. Yeah, I think that's a little outstanding or egregious in its nature to be used. But they always do that. That's easy, a reduction of charges, I would think, to be filed. But how would y'all approach it? What would you be filing? You file an affidavit first, some sort of pleading with a memorandum going over everything, and then have a hearing based on that, going over why it should be dismissed on the forefront and see where things go. I mean, how would y'all take it? What would y'all do?
If
Would
I
you
may,
go directly? Would you go directly on the jurisdictional aspects in relation to
They're standing to
Article
be
3,
there.
Section
Yeah.
2 with the Supreme Court?
if I may, counterclaim
Is her
as unconstitutionally applied.
Notice of plea and abatement. Don't make a plea. Challenge jurisdiction first and foremost.
Okay, so we should hit with an abatement.
I like the counterclaim idea.
Counterclaiming though.
The thing is, if you file any motions, you put yourself in their jurisdiction. So you file a notices first.
Yeah, but remember, you can always challenge it. So if you're coming in hot and heavy and trying to work on that constitutional framework and bringing it out of the statutory, you're right on the motions. How we title it does determine what statutory body of framework they're going to use in the courts. We've established that through Louis. We know that. We have the court admitting to it verbatim. If you're filing a motion, it's under a 8.3 CRR, which is the statutory side. If you're filing a notice and demand as unconstitutionally applied, you're under the constitutional framework side. Those are two different bodies of law in which the courts utilize within the superior and district courts. Okay? We know this. They've told us it verbatim.
Yep.
So what we can do is comprehend. Yeah, through Louise. So what we can do, Stevens County, Washington. So what we can do is understand clearly that there are two bodies of frameworks of law that they utilize. And by doing such, how we title our documents and go in to establish those hearings is how we are able to move within those different body or frameworks. So what I would say is you have every eligibility to challenge jurisdiction every time, and everybody always wants to do that, and that's cool. I get it. You don't want to have to deal with them. This process is weird. There's all kinds of frameworks. There's all kinds of ways to swim in the waters, right? You got your cool waters, you got your hot waters, you got cool reefs, and then you got shit that's just barren. You got nothing. It's rough and rocky. Okay, you gotta move and maneuver in whatever terrain you're sitting in, and that is dependent upon how the court runs the court. You see Quinton's court, and that judge ran it hot shot. While you see on the other side with both Kate, well, you didn't see with Kate, but you saw with Sydney that they didn't enter a plea on their behalf at all and pushed it on to another date, right? So we can see that the waters are kind of murky here. I can't really see clear. We're in some shit with some catfishes, maybe some piranhas might be around. Shit's kind of murky, all right. And in that murkiness, we still got to be able to operate in the highest fashion possible. And that's being able to be quick, witted, being able to maneuver in whatever way, and that's by proper preparation. because those 6 P's or proper preparation prevents piss poor performance. So in that, what we've been able to do is already develop some things, of course, with Palmira. Let me see. I wanted to see if this kind of come through because, yeah, y'all was talking about that article. Is this in a latex? It is. So let me see. Y'all was talking about that. Let me do Palmira.
I got a question.
Go ahead, Papa.
I've never seen cops just jump to a person's orders. So, like, does this ex-girlfriend work in the fucking legal system or something? Does she have a cop boyfriend on the side?
Maybe. She doesn't work in the legal system, so she might have a friendship there. That's what it seemed like to me. Yeah.
They don't even need that. If she and the friend simply told a good enough story that helps fill a gap in cases and more charges they could potentially get in their little sales outfit they have there.
Hey, who gonna be the clerk today? And no, who gonna be the judge today?
I'll be one of them.
Who gonna be one?
Joe.
In regards to what?
I need super clear mics. Who's got clear mics?
My mic not clear?
No, your mic's too
Is
far.
mine clear?
Elira's is pretty
Nominate
clear.
Ty.
Ty does have a clear
Ty's got
mic. He don't sound like
How
you
about
want.
mine? Is mine clear?
Yours is okay. Jack's is clear though.
Mine's pretty good.
Yeah,
You-
Ty and Jack.
I might have to. Okay, as long as it's not gonna be too long. I got shit going on.
What do you got going on?
That's a long story. But I do have to step away every now and then. So
Well, I mean, actually,
I
these
guess
aren't even
let's-
set up.
let's-
These aren't even set up really too much. Actually, where the judge is saying too much. So it's more just about. It's okay. I'll just do it like this. So we got the clerk is saying, "All rise." You know, District of Columbia, be seated. Here we are in the case of the matter of North Carolina versus Palmira Stevens. All parties present. Prosecutors likely responsive identifying themselves. I really like this actually to play itself all the way out. So I'm gonna revise this. Hold on. Can we make the
I have a question.
Yeah, go ahead.
The motion to dismiss, I do not file that one before the court date. I just have it on me in case I need to file it, or do I file it before?
I'd file the ASAP myself.
Yeah, file it way as soon as you can.
Okay.
Can I
And
ask?
make sure you
I'm
make sure
sorry.
you include a certificate of service and serve it on all parties as well for open transparency and good faith.
Okay.
I'm sorry, it's actually, instead of a motion, it's a notice and demand to dismiss. Is that right?
Yes.
You
So
can
it'd
do
be,
either one. It just
it-
depends on how you want to present it to the court, but you can do either one, honestly.
Yeah, and it'd be a notice and demand to dismiss as the statute is unconstitutionally applied. And you'd have a memorandum with that of law, or what they also title point.
Could somebody put that in the chat?
Yeah, I got you. Notice.
Thank you.
I do have a notice and demand to dismiss already, but I haven't filed it. So I just
I'd say
wanted to.
go through, make sure it has everything it needs. If you want, drop it and we'll read through it and file it ASAP.
Yeah, she got this notice to dismiss right here.
that
2
one.
days she was working on it. 2 days ago, she be working, y'all. Look on every one of her documents. Look where it say. Look at her. Ooh, look at her. Brrr. She been working on all her shit, y'all.
The ones that say 9 days, I already filed those.
You see what I'm saying? All right, so let me see where we at. Yeah, Palmira been working for real though. So we hit for a notice and demand with points and authorities. See the title, notice and demand, points and authorities. Notice is hereby given to the Honorable Court in the state of North Carolina that the statutes under which the charges in this matter are brought under unconstitutionally as applied to Palmira, a living woman appearing especially and not generally in propria persona sui juris. This notice and demand to dismiss is submitted pursuant to the Creator endowed unalienable rights recognized in the Declaration of Independence, the Constitution for the United States of America, the Constitution of North Carolina, and the principles of natural law that supersede all statutory constructions that infringe upon fundamental rights. And then a notice to the constitutional challenge pursuant to North Carolina General Statute subsection 1-260 and the requirements articulated in the Fifth Third Bank National Association. Palmira Stevens hereby gives formal notice that she is challenging the constitutionality of the North Carolina General Statute subsection 14-223, resisting public officer, which is crazy due to the fact that if she's like got a fused hip and she has to move in a certain way and they feel that tug and they're like, oh, you're resisting. And it's like, oh, don't touch me. You don't have a warrant for my arrest. And they're like, oh, you're resisting. It's like, no, but you don't have a right to detain me. Get away from me. And they're like, you're resisting. It's like, no, you're defending yourself for an unconstitutional act. Again, the officers of the law in the execution of process are required to know the requirements of the law. Okay, that includes creator endowed rights and all, bro. That's like, if you don't know, that's not my fault. Don't get mad at me. It's not my fault that you're ignorant of how things work. And if they mistake them, whether through ignorance or design, and anyone is harmed by error, they must respond in damages. It is what it is. You can't get away from that. Okay, period. The application of a code to detain appellant and require her to identify herself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe appellant was engaged or had engaged in criminal conduct. Jeez Louise. Accordingly, appellant may not be punished for refusing to identify herself, and the conviction would be reversed. I don't know what it's already been established. Demand for the dismissal with points and authorities. The statutes are unconstitutional as applied. Resisting public officer and the authority of that. The application of General Statute 14223. Document with to a person with a document physical disability who is physically unable to comply with certain commands due to that disability violates the American Disabilities Act, the authority behind that. The application of NC General Stat 14223 to criminalize non-violational physical limitations constitutes a status crime in violation of the Eighth Amendment and Article 1, Section 27 of North Carolina's Constitution, and the authority behind that. And then the carrying of a concealed gun. The application of NC General Stat subsection 14-269A1 to a person lawfully present on private property with the owner's express permission violates the Second Amendment to the United States Constitution and Article 1, Section 30 of North Carolina's Constitution, and the authorities beyond that, backing that. And the application of, again, 14-269A1 in direct contravention of the statutory exemption provided in subsection 14269B for persons on their own premises or premises where they have permission violates due process under the 14th Amendment and Article 1, Section 19 of North Carolina's Constitution, the authority behind that, and its application to a person who had no intention or ability to leave private property violates the fundamental principle that criminal statutes must be strictly construed against the state. And then, the misdemeanor larceny, the application of, again, another statute without proof of knowledge or intent violates the due process clause of the 14th Amendment. Now, when we talk about knowledge and intent, what does that boil down to in Latin one more time, y'all?
Mens rea.
I got you.
Actus reus.
Mens
There
rea,
you go.
actus reus.
There you go. Bring it forth. You dig? Article 1, Section 19 of the North Carolina Constitution. The application is that to criminalize the mere possession of another's property without proof of taking or aspiration violates the fundamental principle that criminal statutes must be strictly construed against the state. The application would be without proof of the corpus delicti, independent of an alleged omission violates the corpus delicti rule of due process. Now, people might be thinking, well, the other person there, the girl, she's the verified complaint. What's she complaining against when she was the one who attacked Palmira? She's saying she took her stuff. What stuff? You talking about the guns that are registered? Now one gun is honestly missing. Who are they registered? Are they registered to her? Or are they registered to Palmira? I mean, not Palmira, but her brother. You dig what I'm saying? Like, what's really going on out here?
Not only that, what did she claim that she had stolen? What items did she steal that fit in that bag?
Right.
She didn't even know about anything. She didn't know what it was in the bag either.
Well, what's crazy?
Exactly. She made presumptions.
Presumptions, and there was no warrant. There has to be a notice given, and then there has to be an opportunity first off. So they have to go get a warrant before they can even search the bag. Like, I don't know what's going on here. Like, this is really crazy that these people acting like that.
Prior to this, I've never had any criminal record, not even a parking ticket, no speeding ticket, nothing. Like I've never had it to deal with the law ever. They're not taking that into consideration either.
Just to be devil's advocate here, you know, they could allege Terry Frisk. I can't remember the case, but that alleged crime is being committed. That
Well,
she
alleged crime.
right.
What they
Alleged
gotta have
crime on
probable
private
cause.
property
Yeah.
when she has owner
If the
permission
woman
to be
was
on.
if the woman was saying that she was in the process of stealing her property, I'm just throwing stuff out
No,
here.
that's good. That's good. No, yeah, for sure, for sure.
They
So
did use that.
there would be a perjury aspect there, then, right?
Yeah, but
It doesn't count because it wouldn't have been verified. She did not sign that under the pains and penalties of perjury under the laws of the United States of America.
Very true. Very true.
Yeah, they might be able to detain her until they can get a warrant, but they can't just
all of
search her
private
stuff.
property. Right.
Yeah,
Arrest
Yeah, but
then
this
search.
But what was the
not unless
original
she
reason
agreed
why-
to it.
But what was the original reason why the officer and the ex-girlfriend was there?
Exactly.
To get the
They would-
ex-girlfriend stuff in the house.
And second,
the
what gave
excuse.
what gave the sheriff's jurisdiction that he can arrest anyone on that property?
Yeah.
And there was no,
Exactly.
and one who committed the any crime or any assault was the ex-girlfriend when she lunged onto what was her name?
Palmira.
Palmira.
Yes.
Yeah.
And that was committed in front of the officer. So
Mm-hmm.
that's what's confusing me right here.
Yes. And then when I tried to press charges, they didn't allow me to because they said, oh, the officers were present. So
That might be where a
Yeah.
counterclaim comes in.
Yeah.
Yeah, I'd still do my own charges in general. You don't really need the sheriff to do charges.
Yeah, explain that a little more. What do you mean by that? Because I would get stuck if I went there and they told me that, and I was like, you guys are liars, but now I got to go figure out what the heck just happened. Why do you say that?
Anyone can file a complaint with the court to start a case.
Another thing that I want to
Oh.
bring, someone's vehicle's doors or automobile doors are open besides the driver's side. Whose vehicle was that?
mine.
Why was it open like that? Did you leave it open like that or?
No, after she attacked me, I walked into my car, just to be, that was like my next safe place to be since they didn't want me in the house. So I said, I told the sheriff, I'm gonna be in my car while you allow her to go get her stuff. And he agreed. But as soon as she attacked me and since she couldn't take the backpacks from me, I stepped into my car and she immediately started screaming. So the sheriffs opened all the doors of my car before I could lock it or lock myself in there, And so they opened them.
So they opened the doors.
Yes.
So you didn't give them consent, authorization to open up the doors?
No, not at all.
That's really weird. In fact, you can sue them for that because
They're required to ask for consent in the beginning.
Failure to obey a command of a police officer constitutes a traditional form of breach of the peace. Obviously, however, one cannot be punished for failing to obey the command of an officer if that command is itself violative of the Constitution.
Right.
Like, what you talking about?
Perfect.
That an officer or employee of the state or one of its subdivisions is deemed to be acting under color of law, is deemed to be acting under color of law, statutory law. As to those deprivations of right committed in the fulfillment of the tasks and obligations assigned to him. Actions by state officers and employees, even if unauthorized or in excess of authority, can be actions under color of law. The police power of the state must be exercised in subordination to the provisions of the U.S. Constitution. Like, what y'all talking about? But even assuming that purpose, prevention of a crime, is served to some degree by stopping and demanding identification from an individual without any specific basis for believing she is involved in criminal activity, the guarantees of the Fourth Amendment do not allow it. The application of a code, we already just read that one though, it just comes right back to it. It's like you can't violate me not wanting to be private and not violate it so that you can bring forth your charges against me. Like, that's not how this works. There's so many elements here that must be broken before they just do whatever the fuck they want. And that's what I'm saying. It's crazy. She on her own private property with permission from her own family member, and they over here bringing forth that we're going to do what we want to do to you now. Like, bro, how? Why? Why?
Heck, Sean just said it right in the chat. Fourth Amendment violations. They allowed a violation of her person by allowing that other woman to jump on her. They allowed a violation of her property by opening the doors of her automobile and searching through her bags. There's violations all around on their hands. They did not do things properly at all.
I got it. Y'all ready?
Yeah.
All right. Who gonna be the judge? Who gonna be the clerk? Who gonna be the prosecutor?
Well, I can read, but my phone glitches out and sometimes blurs out the text. Does yours do that,
I
hon?
vote.
I can. Does my
Does
mic
too.
sound better? I can read if
Oh
it
yeah.
sounds better.
Joe sounds
I
way
vote
better.
tie for administrator.
I'll be the prosecutor. Joe's gonna be the judge.
All right.
Alira's gonna be the clerk.
I'll be Palmira.
Yeah, you'll be Palmira.
All
Yeah,
rise. District Court of North Carolina, Chatham County, the Honorable Judge Joe presiding.
Be seated. We're here on case number 25 CR 29070117. Blah blah blah. State of North Carolina versus Palmira Stevens. Are all parties present?
Good morning, Your Honor. Assistant District Attorney Wilson for the state.
I am the woman commonly known as Palmira Stevens, appearing specially and not generally in propria persona sui juris by special visitation only, and without prejudice to any of my unalienable creator-endowed rights.
Miss Stevens, we're here for your arraignment. Do you have a copy of the charges against you?
Your Honor, before any arraignment can proceed, I must challenge this court's subject matter jurisdiction. I appear today solely for that purpose. I do not waive any rights, and this special appearance is not to be construed as a general appearance or submission to this court's jurisdiction.
Your Honor, the state objects. This is a transparent attempt to delay these proceedings. She's a sovereign citizen. This court has clear jurisdiction over misdemeanor offenses committed in Chatham County under NC General Statute 78272.
The state's objection is noted. Ms. Stevens, you may proceed with your jurisdictional challenge, but be advised that I will not allow this to become a lengthy filibuster. Be concise and to the point.
Thank you, Your Honor. With all due respect to the prosecutor, it is well established in both federal and North Carolina jurisprudence that subject matter jurisdiction cannot be presumed or inferred, but must be proven when challenged. As the North Carolina Supreme Court held in State versus Bedford 293, North Carolina 486, when jurisdiction is challenged, the state must carry the burden and show beyond a reasonable doubt that North Carolina has jurisdiction to try the accused. The state has yet to present any evidence to meet this burden.
You're right. Case dismissed. Like
It should be.
Seriously.
Okay, keep going.
Your Honor, my challenge to this court's subject matter jurisdiction is grounded in several fundamental constitutional principles. Article 1, Section 19 of the North Carolina Constitution guarantees that no person shall be taken, imprisoned, or deceased of his freehold liberties or privileges, or outlawed or exiled or in any manner deprived of his life, liberty, or property, but by the law of the land. This provision requires that courts possess proper subject matter jurisdiction before exercising authority over an individual.
Your Honor, the defendant is simply reciting general constitutional principles that have no bearing on this court's jurisdiction. The state has filed proper charging documents in the appropriate venue for misdemeanor offenses committed in Chatham County. That is all that is required to establish jurisdiction.
Ms. Stevens, I'm familiar with North Carolina Constitution. How do these general principles specifically challenge the court's jurisdiction over your misdemeanor charges?
Your Honor, these are not merely general principles, but the fundamental law that limits this court's authority in Red TRP 360 and C 588. the North Carolina Supreme Court emphasized that subject matter jurisdiction is the indispensable foundation upon which valid judicial decisions rest, and in its absence, a court has no power to act. Without established subject matter jurisdiction, any action by this court would be void ab initio. The prosecution has not established the essential elements necessary for jurisdiction over these specific charges.
The court is well aware of its jurisdictional limitations, Ms. Stevens. However, North Carolina General Statute 7A-272 clearly grants this court's jurisdiction over misdemeanor offenses. Your charges fall within that category. What specific jurisdictional defect are you alleging?
Your Honor, this court lacks subject matter jurisdiction because the prosecution has failed to establish the corpus delicti for each of the charges against
Real fast. Delecti. Yep.
Delecti. Okay. For each of the charges against me. For the charge of resisting public officer under North Carolina General Statute subsection 14-223, the prosecution must prove willful and unlawful resistance as established in State versus Sinclair 191 North Carolina APP, I don't know. Appellate 485, merely questioning an officer's actions or explaining one's physical limitations does not constitute resistance. My documented medical condition, a fused left hip, render me physically incapable of complying with certain commands. Physical inability negates the willfulness element required by the statute. Without this essential element, no crime exists, and this court lacks subject matter jurisdiction over this charge.
Your Honor, whether the defendant's actions were willful is a question of fact for the jury to decide at trial, not a jurisdictional issue. The charging document alleges willful resistance, which is sufficient to establish jurisdiction for this arraignment. The defendant is improperly attempting to litigate the merits of her case under the guise of a jurisdictional challenge.
I'm inclined to agree with the state on this point, Ms. Stevens. The issue of willfulness is a factual matter for trial. The charging documents alleges all the elements of the offense, which is sufficient to establish jurisdiction. Move on to your next point.
I know my exception for the record, Your Honor. The absence of an essential element of the crime is a jurisdictional defect, not merely a factual dispute. Regarding the charge of carrying a concealed gun under North Carolina General Statute subsection 14-269A1, the prosecution must prove that I carried a concealed weapon outside the statutory exceptions. North Carolina General Statute subsection 14-269B explicitly exempts a person on the person's own premises, which includes lawful guests with permission. In State versus Spruill 237 North Carolina Appellate 383, the North Carolina Court of Appeals held that the private premises exception applies to lawful occupants. As a lawful guest on my brother's property with his express permission, I fall within this statutory exception. Additionally, the weapon was in my brother's backpack, which I was holding for him, and the vehicle was inoperable with the engine off, further exempting me under North Carolina General Statute subsection 14-269B1.4. Without a violation of the statute, no crime exists, and this court lacks subject matter jurisdiction over this charge.
Your Honor, the private premises exception is an affirmative defense that must be raised and proven by the defendant at trial. Okay, it does not divest this court of jurisdiction. The state has alleged a violation of the statute, and that is sufficient for these proceedings to move forward. Furthermore, the defendant was not inside a private residence, but in a vehicle on the property, which may not qualify for the exception. That is a factual determination for trial, though.
Again, Ms. Stevens, that sounds like a defense to be raised at trial. The charging document alleges a violation of the concealed carry statute, which is sufficient to establish jurisdiction. Do you have any arguments that go to the fundamental power of this court to hear this type of case at all?
Yes, Your Honor. My final point on the corpus delicti goes to the heart of this court's power. For the charge of misdemeanor larceny under North Carolina General Statute subsection 14-72A, the prosecution must prove the intent to deprive the owner of property. In State versus Reeves, 62 North Carolina Appellate 219, the North Carolina Court of Appeals held that the larceny requires both taking and carrying away with felonies intent. I had no knowledge that my sister-in-law's mail was in my brother's backpack, which I was holding for him with his permission. Without knowledge or intent, no crime exists, and this court lacks subject matter jurisdiction over this charge.
Your Honor, again, intent is a classic jury question. The state is not required to prove its entire case at arraignment. The allegations in the charging document are sufficient to proceed. The defendant is attempting to have this court conduct a mini trial on the merits, which is inappropriate at this stage.
I agree with the statement, Stevens. I'm not persuaded that the arguments divest the court of subject matter jurisdiction. These are factual disputes and defense to be raised at trial. Do you have any other grounds for your challenge?
Yes, Your Honor. This court's subject matter jurisdiction is further negated by multiple constitutional violations that render these proceedings void ab initio. The Fourth Amendment to the United States Constitution and Article 1, Section 20 of the North Carolina Constitution protect against unreasonable searches and seizures. My arrest was conducted without a warrant and without probable cause, based solely on instructions from my brother's girlfriend, who had no authority to consent to a search of my person or my brother's backpack in my possession. In State versus Grady, 372 North Carolina 509, the North Carolina Supreme Court held that a search conducted without proper authority violates the North Carolina Constitution. These constitutional violations render the arrest and subsequent charges void from inception, depriving this court of subject matter jurisdiction.
Your Honor, any Fourth Amendment issues are properly addressed in a pretrial motion to suppress. They do not strip the court of jurisdiction to hear the case. The defendant is confusing substantive defenses with jurisdictional challenges. Even if the search were later found to be unconstitutional, that would result in suppression of evidence, not a dismissal for lack of jurisdiction.
Prosecutor is correct, Ms. Stevens. If you wish to challenge the legality of the search and seizure, you may file a motion to suppress. That is the proper procedure. It does not affect the court's jurisdiction to hear this case.
I note my exception for the record, Your Honor. Furthermore, Title II of the Americans with Disabilities Act applies to all state and local government activities, including arrest and court proceedings. When I explained my fused hip condition to the arresting officer, he ignored my disability and continued to force my leg into positions it physically cannot achieve, causing severe pain and injury. In Sermeth versus Board of County Commissioners, Frederick County, 673 F3D 333 of the Fourth Circuit, the Fourth Circuit held that the ADA applies to police interactions with disabled individuals. The failure to accommodate my disability renders the arrest unlawful and deprives this court of subject matter jurisdiction.
Your Honor, an alleged ADA violation is a matter for civil suit, not a criminal jurisdictional challenge. It does not negate the fact that the defendant was charged with a crime in this county. The defendant is attempting to conflate potential civil rights violations with criminal jurisdiction. They are separate legal matters.
I'm not aware of any precedent that an ADA violation during an arrest divests the criminal court of jurisdiction. Do you have any such case law, Ms. Stevens?
Your Honor, in Tennessee versus Lane 541 U.S. 509 in 2004, the Supreme Court recognized that the ADA applies to the fundamental right of access to the courts. When my disability was used as the basis for a criminal charge, being physically unable to comply with commands due to my fused hip, it creates a jurisdictional defect. This court cannot acquire jurisdiction from a void act that itself violates federal law.
Tennessee v. Lane addressed physical access to courthouses, not the effect of ADA violations of criminal jurisdiction. This is a novel legal theory, Ms. Stevens, but it is not one that I find persuasive. Do you have any other jurisdictional arguments?
Yes, Your Honor. This court's subject matter jurisdiction is further compromised by the unauthorized practice of law that has occurred in this case. The attorney who purported to purported to represent me was hired by my brother without my consent, made deals with the district attorney without consulting me, changed my court date and location without proper notice, and withheld certified copies of my file that I purchased from the court. May I say something?
Yes, what are you talking about, may I? Go ahead, say what you want to say, girl.
So the attorney, I did go see him once, so I guess I did give him consent to
Wait,
represent me at
with your
first.
brother?
Yeah, with my brother together. I
Okay.
went just to explain the case.
Okay, so so you went just as a supporting witness to your brother's situation, right? Or did you go with like the intent to hire him for your case?
Yes, that was before I ever even thought of presenting myself. So my brother was like, I'm gonna get us a lawyer. So I went with him and I said, I don't know this lawyer. He's like, just listen to him. So we just went and explained what was happening to see if we wanted him to represent us, but we didn't sign anything. He's still
Consultation.
representing my brother though. Anyway, also, he didn't withheld the certified copies. He tried, but I said no. He said, may I keep these? And I said, no, these are mine. You can get your own. I bought these from the court, so I didn't allow him to keep them. He did try them.
Then just change that phrasing, because you can go through and you can change the wording and the stuff. Like
Oh,
at one point it says it's your sister-in-law. You can go through and correct that wording.
I will.
Or even correct it on the fly while you're doing it.
Yeah.
Yes. Okay. Thank you. So I just wanted to say that.
Improvise.
I'll be right back.
So, Palmira, yeah, to add on to that, it's you can go and have a consultation with that attorney, and just, it's the intent isn't in there to go and hire them right on the spot. It's to see if you are in agreement and you want their services, which you don't, and so now you put him on notice, you put the court on notice that you don't have any representation. You're there in propria
persona.
Yeah.
Propria persona sui juris.
Yep.
Propria persona.
And so anyway, just just stand on that principle.
Okay.
Going in there just to have a consultation and speak with another attorney does not mean you're hiring them.
Yeah.
Yeah, and Troy just said it right. That's your brother's attorney, not yours. There's a conflict of interest.
Yes. Yeah, it's from the beginning.
Sure.
I didn't like it.
I'm not sure. So Troy, you say the same lawyer cannot represent you both. What do you mean? Like you couldn't hire the two of them couldn't hire the same attorney for that case?
Okay. So the attorney
is what Troy said. They won't let it.
The attorney said that he could. He at first he thought there would be a conflict of interest, but then he said, "Oh no, it's there won't be one." So I guess he checked, and there wasn't one. I don't know.
Sorry, I had to go to the bathroom.
And he continued to say to represent us. Yeah.
Which is weird, and it's like he's mad. Is he mad or something?
Oh, he's very mad. Like, he said to my brother, he tried to tell him that I'm crazy. He said, I don't know what's in your sister's mind, because nobody had ever fired me before. Like nobody had ever written. And I don't know if you understand that everything she filed is public. So yeah, he's very mad. And he wrote me a letter rebutting to every point I wrote why I fire him. And he said, I wish you luck.
Well, that's good. At least he wished you luck on everything.
Yeah.
He was rebutting everything too.
Yes.
That's kind of crazy. All right, did you finish this statement here or no?
No.
Oh.
Okay, so these actions violate North Carolina General Statute subsection 84-4, which prohibits the practice of law by persons other than members of the state bar. When an attorney purports to represent a person without proper authorization, they violate this statute by effectively practicing law on behalf of a non-existent client relationship.
Your Honor, any issues with prior counsel are completely irrelevant to this court's jurisdiction. If the defendant believes her prior attorney acted improperly, she can file a complaint with the state bar. It has no bearing on whether this court has jurisdiction over these criminal charges.
I agree with the state. Ms. Stevens, issues with your prior representation do not affect this court's jurisdiction, this court's subject matter jurisdiction. If you wish to file a complaint against that attorney, you may do so with the North Carolina State Bar. Is there anything else you wish to present on the jurisdictional issue?
Yes, Your Honor. Beyond the constitutional and statutory basis for my challenge, I must emphasize that the limitations of this court's subject matter jurisdiction are rooted in natural law principles that predate and transcend governmental recognition. As acknowledged in the Declaration of Independence, all individuals possess certain unalienable rights that are endowed by their Creator. Sorry. These natural rights include the right to be free from unauthorized judicial proceedings that lack proper jurisdiction.
Your Honor, the defendant is now making philosophical arguments rather than legal ones. The Declaration of Independence is not binding law. These abstract natural law principles have no bearing on this court's jurisdiction under North Carolina law.
Ms. Stevens, while I appreciate your philosophical perspective, this court operates under the Constitution and laws of North Carolina and the United States. I need legal arguments based on those authorities, not abstract principles.
Your Honor, these principles are recognized in Article 1, Section 36 of the North Carolina Constitution, which acknowledges that the enumeration of rights in this article shall not be construed to impair or deny others retained by the people. This provision recognizes the existence of natural rights beyond those explicitly enumerated. My jurisdictional challenge is grounded in both positive law and these constitutionally recognized natural rights.
I have considered all your arguments, Ms. Stevens, and I am not persuaded that this court lacks subject matter jurisdiction. Your arguments primarily go to the merits of the case or potential defenses, not this court's fundamental power to hear misdemeanor cases in Chatham County. I am denying your motion to dismiss for lack of subject matter jurisdiction. We will now proceed with the arraignment. How do you plead to the charges?
Now wait, before we move forward. Once you get a denial verbally like that, what are you going to be doing?
I will object.
Yep.
Object? What will you be asking for?
I will, on the record, require that
get it in writing. Get it in writing. I need the
Judicial notice.
Yep. Go ahead, y'all. Y'all tell her.
Your Honor, can you make a judicial determination for your motion to dismiss my subject matter jurisdiction?
Written determination. Never forget to say written determination.
Need it in writing, a formal written determination in writing.
Okay.
Need it in writing. If you don't object and ask for it, it will not be reviewed upon in any appeals at all. They won't even think about it. You better raise that bad boy.
Anything you don't object on, they'll ask you, why didn't you object on it during then if you knew it was an issue? That's why you have to object. Even if they're just going to disregard it, still make that objection for appeal.
Okay, go ahead.
Your Honor, I respectfully note my exception to the court's ruling and request that my objection be preserved in the record for potential appellate review. I maintain my challenge to this court's subject matter jurisdiction and do not waive any rights by proceeding under protest.
Perfect.
As held in State versus Batford, when jurisdiction is challenged, the state must carry the burden and show beyond a reasonable doubt that North Carolina has jurisdiction to try the accused. I respectfully submit that this burden has not been met.
Your objection is noted for the record. Now, how do you plead to the charges?
Your Honor, I cannot enter a plea without first having the jurisdictional issue properly settled. To do so would be to waive my challenge and consent to these proceedings, which I do not. I stand on my challenge to the subject matter jurisdiction of this court and request that the court either dismiss the charges for lack of jurisdiction or schedule a separate jurisdictional hearing where the prosecution must present evidence establishing this court's subject matter jurisdiction beyond a reasonable doubt.
Your Honor, the defendant is now refusing to participate in the arraignment. The state requests that the court enter a plea of not guilty on the defendant's behalf and set this matter for trial.
Ms. Stevens, if you refuse to enter a plea, the court will enter a plea of not guilty for you. This is your final opportunity to enter a plea yourself.
Your Honor, I am not refusing to participate. I am asserting my right to have the threshold issue of jurisdiction properly addressed before these proceedings can lawfully continue. I cannot consent to proceedings that I believe are void ab initio. I respectfully request that the court either dismiss the charges for lack of jurisdiction or schedule a separate jurisdictional hearing.
Very well. The record will reflect that the defendant is present, has been advised of the charges, and refuses to enter a plea. The court hereby enters a plea of not guilty on behalf of the defendant. The matter is set for trial on such and such. Ms. Stevens, you are ordered to appear. We are adjourned.
Then you got alternative scenarios too. Y'all want to go through this?
Objection. Can we put an objection there? Just this.
Go ahead.
Rejection defendant. No, a defendant is object to defendant, Judge. I have not agreed to be a defendant.
Exactly. Okay, well, you're breaking up, so you're going to say it right. And
I'm a defendant. Please rule on the objection. Your Honor, I object. I'm not a defendant. I object, Your Honor. I'm not an actual defendant. I've not agreed. Defendant. I'm merely the accused. Please. And that be in the record as well. And I hear from the record. And I hear the place that on the record. Never mind him do it. Screw that.
All right, so let's do an alternative. If the judge grants a jurisdictional hearing, go ahead, Joe.
Ms. Stevens, while I'm not persuaded by your arguments at this time, I recognize the importance of jurisdictional issue. I will schedule a separate jurisdictional hearing where the state must present evidence establishing the court's jurisdiction beyond a reasonable doubt. The hearing will be held on August 15th. Both parties should be prepared to present evidence and arguments on the jurisdictional issue only.
Thank you, Your Honor. I appreciate the court's consideration of this threshold issue. I will be prepared to proceed with the jurisdictional hearing on that date.
Yeah, Your Honor, the state objects to this unnecessary delay. However, we will be prepared to establish a jurisdiction at the hearing.
The objection is noticed. We're adjourned until the jurisdictional hearing.
Now, if the judge becomes hostile.
Ms. Stevens, I've heard enough of this frivolous arguments. The court clearly has jurisdiction over misdemeanor offenses in Chatham County. Your motion is denied. How do you plead to the charges?
Your Honor, with all due respect, I must note my exception to the characterization of my arguments as frivolous. The North Carolina Supreme Court has explicitly held in state...
Ms. Stevens, I'm familiar with the law. Your motion is denied. How do you plead?
I respectfully request that my objection be noted on the record. In the record, I cannot enter a plea without waiving my jurisdictional challenge. I request that the court either dismiss the charges for lack of jurisdiction or schedule a separate jurisdictional hearing.
A plea of not guilty will be entered for you. We're adjourned.
If the prosecutor offers to dismiss some charges. Your Honor, in the interest of judicial economy, the state would be willing to dismiss the resisting and larceny charges if the defendant would agree to plead to the concealed weapon charge.
Your Honor, I cannot accept such an offer because it would require me to waive my jurisdictional challenge and consent to these proceedings. Furthermore, as I have explained, I fall within the statutory exception to the concealed weapon charge as I was on private property with permission. I maintain my challenge to this court's subject matter jurisdiction over all charges.
The defendant has rejected the state's offer. Will proceed as previously ordered.
So what about an alternative scenario where you accept the value for consideration of the charging instrument and wish to return it to the court for the bond to be released?
So isn't that the secured party process?
Yeah, that's the use of L sort of take on it. And that's separating you from the person or the corporation. And you're saying basically this is a commercial transaction. This is a civil matter. This is about money. You guys want the money, so just release the bond and the charges are paid for and bye-bye.
So what are you going to make a special endorsement for that?
Well, if they are willing to allow you to endorse the instrument, all you do is sign UCC 1-308 accepted for value, and that's a commercial process that the clerk can handle. That's what this is all about. This is all about commerce, so this is another take on it that is fundamentally about Article 1 courts.
So how do I bring this up?
Well, this
wait,
is
wait. So this is going to be the issue here. We're going to have people getting prepared for following the process and then getting people confused with following other processes while not knowing the initial baseline process.
And I agree with you, Cam.
Okay, so we don't want to get Palmira confused here now with the deeper aspects on things that nobody can show proof of that has been successful. And if you can, please bring it forth now, like right now.
Right. Well, I'm just suggesting
I was just saying that to my husband.
A possibility
I don't even
of
want to talk. No, I don't even want to talk about it if you ain't got no proof right now. I don't care about what somebody talks about. I don't want to know what anybody's talked about. I don't want to know what they brought up and how it could possibly work in theory. I want to see proof right now. I want to see a dismissal right now. Show it.
You're safe to move on from this. It's something we would deal with right now.
Thank you. I'm not even going to talk about it. You ain't got no proof. Don't talk about it.
No,
That's how it works.
get it
Follow
gone.
the process and stand on what you are. Okay? If there's some back end stuff and you want to show me that you've done it, cool. Show it up, broski. Until then, stop talking about it. I've gone through all of that, cuz I'm telling you now, go waste your time like I did for 3.5 years.
Okay, I got something to say about the script. So far, it's really good, but the point has already been brought up that we need to demand the written notice on the record, and we've went through a couple scenarios, maybe probably 3 times where that should have been done, where the judge scheduled another date, and then nothing was said, and it moved on to the next court date without that objection being done. So I just want to make that real clear that's something that needs to be done.
For sure. Yeah, more objections can be brought forth. This is just a script kind of for preparation on what could happen, right? So any person can start to understand, okay, well, some things I need to bring up, some things I need to bring into the record, some things I'm looking at. She's got actually multiple scripts. I just made this quick script on the fly and it really didn't even bring forth what I wanted it to bring forth, to be honest with you.
Yeah, I've been practicing the one that I already had.
Yeah, that one. Then this one right here was an extended one, and I don't even know what it got extended. I don't even think we did. Yeah, because I already downloaded it. But yeah, it was supposed to be more or less about the Article 2 aspect of what I wanted to bring forth. For what y'all was talking about, Article 2, Section 3, or Article 3, Section 2? Which one was it? I forget.
Article 2.
Article 3, paragraph 2, Section 2.
Clause 2.
Yeah.
Yeah.
322.
322. Oh God.
Just like the Skull and Bones.
I was about to say just like Skull and Bones. That's crazy. See, you gotta watch it.
You said that literally a millisecond before you said that. My husband just said that about the Skull and Bones.
Yeah, I know.
Dang, Wesley.
I mean, I know about them secret societies too, bro. Come on now. Okay, so let me see. Palmira. Let's check out the other one.
Hey, My husband wants to know if anyone's ever read Genesis 3, section 22, or line 22, whatever it is. Verse 22, my bad.
I don't know what's to say.
Chapter 3, verse 2.
I don't know, I'd have to pull out the Bible.
That's where the fall of
Hold
man
on.
is.
He's gonna pull it up real fast. Yes, we have a Bible in our truck.
Hey,
Cam.
And the woman said unto the serpent, we may eat of the fruit of the trees of the garden.
Yes.
Cam, I got a question on that, on something in that script.
Uh-huh.
The part there where the declaration was brought up, what was said to that reply? Was that the declaration was not a legal document or something?
Yeah, it wasn't law, it's philosophical.
Okay, but in reality, it is relevant because the declaration is a legal document and was made legal through the Lee resolution, which makes it important to be able to use it for your freedoms, liberties, and so on. So maybe a little argument against that.
Right.
Yeah, I mean the prosecution and even the judge are gonna rule. They're gonna be in favor of the municipal corporate state. So yeah, you got to be prepared for that and say, no, what are you talking about? The independence, the Declaration of Independence doesn't matter.
Yeah, but I also feel as though you can be very strategic on what you letting slide by and what you not letting slide by.
Yes, that's what I'm getting at.
Example is like, I love you, girl, but don't be mad at me. Like Lana, she be arguing with her judge like crazy. They be going back and forth, back and forth, back.
Honestly, I wasn't arguing the first time, and he just totally fucked me over. And it's because of the PD thing. I was making an attempt to try to be heard, and he just was not having it in this last case.
Yeah, y'all were going in on each other. Y'all sound
Well,
like
he's
a
already
married
prejudiced
couple
against
after
me, that was
30,
true.
30 something years. Like one of those ones that
Yeah.
just be at each other really hard. That's what y'all sounded like. Y'all was going back and forth like that, and I was like, oh no.
All right, we found 322 of Genesis. And the Lord God said, behold, the man is become one of us, to know good and evil. And now lest he put forth his hand and take also of the tree of life and eat and live forever.
Yeah, what about it?
Yeah, what
That's
about?
Genesis 322, which is also the skull and crossbones number 2, 322, which is also Article 3, Section 2, Clause 2.
Well, watch it. It also falls into the aspect as do as thou wilt, right?
Yeah, that's actually the main thing when with the tree of knowledge and to know good and evil is the fundamental principle of what we're arguing about, or not what we're arguing, but the fundamental principle of the issue we have here today, because we have man knowing, making good and evil, making their own laws that try to usurp the natural laws that God has over us. And so we go in, we take the fruit of the knowledge of good and evil, and we make our own laws. And now we try to exercise authority that we don't have over our fellow man. And so that's what the fall of man is, what we're fighting here right now. We're trying to get out from under the man-made laws and live under God's law. And anyway, it's the fall. The fall of man is what caused all of this, because we wanted to make up our own laws.
Love you all. I'll catch up with you later. Cam, I know I need to get with you like ASAP. So I appreciate you all. Have a wonderful
Love you, Lana.
Later, Lana.
Bye, Lana.
All right, you want to do one more, y'all?
Whatever you want.
Okay, yeah, these are cool because this is another one. It's different though.
I think we're gonna jump off for a little bit.
Okay,
I
y'all
will be
have
back
fun.
if you're still here in an hour.
Oh, maybe they'll probably still be here in an hour, but we got
Thank
30
you
minutes
for
left for the main
being
show.
here.
Later, Lyra and Wesley.
Bye, Lyra. Okay. Let's keep the same people. Ty, you want to jump in or no?
Yeah, I can come in.
All right, Ty, you be the court on this one. And Palmira, I don't see Anything but the court on the? Oh, there is a couple prosecutors. I guess someone can jump in on these ones. Okay, go.
State of North Carolina versus Palmira Stevens.
Your Honor, I am the woman commonly known as Palmira Stevens. I am here making a special appearance, not general, in propria persona sui juris by special visitation only, and without prejudice to any of my unalienable rights. I do not consent to these proceedings until jurisdiction has been proven on the record.
Ms. Stevens, are you representing yourself in this matter?
Your Honor, with all due respect, I am not representing anyone. I am the living woman, Palmira Stevens, appearing in my sovereign capacity. I am not appearing as the legal fiction Mrs. Stevens that appears in all capital letters on the charging documents. I am here solely for the limited purpose of challenging jurisdiction in personam, in rem, and subject matter. And I reserve all my rights under UCC 1-308, formerly 1-207.
Very well. How do you plead to the charges?
With all due respect, Your Honor, I cannot enter a plea at this time as that would constitute a general appearance and waive my jurisdictional challenge pursuant to North Carolina Rules of Civil Procedure, Rule 12B, and the principles articulated in State versus Grady, 372 North Carolina 509 in 2019. A jurisdictional challenge must be heard and determined before any other matter proceeds. I have filed an affidavit of facts challenging jurisdiction, and I move the court to address this threshold issue before proceeding further.
The court notes your objection, but we need to proceed with arraignment.
Your Honor, I must respectfully object. The court is attempting to proceed without establishing jurisdiction on the record. It is well-established law that once jurisdiction is challenged, it must be proven, not merely presumed or declared. I direct the court's attention to McNutt versus General Motors Acceptance Corp. 298 U.S. 178 of 1936, wherein the Supreme Court held if any tribunal finds absence of proof of jurisdiction over person and subject matter, the case must be dismissed. The burden of proving jurisdiction rests with the party asserting it, in this case, the state of North Carolina.
Ms. Stevens, this court clearly has jurisdiction over criminal matters in Chatham County.
Your Honor, this court clearly, Your Honor, with all due respect, that is a conclusory statement, not proof of jurisdiction.
Facts.
General jurisdiction over criminal matters is distinct from a specific jurisdiction over this particular case and this particular woman. I have submitted a verified affidavit of facts that rebuts the presumption of jurisdiction on multiple grounds.
Okay.
First, subject matter jurisdiction is lacking because the state cannot establish the corpus delicti for any of the charged offenses. For the resisting arrest charge, my actions constitute attempts to communicate my documented medical condition, not willful resistance. For the concealed weapon charge, I was on private property with the owner's permission, which is explicitly exempted under North Carolina General Statute subsection 14-269B. And for the larceny charge, I had no knowledge of the male's presence in my brother's backpack and lacked any intent to deprive anyone of property. Second, personal jurisdiction is lacking because the deputy's actions, including unlawful search and seizure, excessive force, and arrest predicated on unreliable information, violated my constitutional rights.
Unreliable information for sure, like an attacking crazed woman over here. Like this unreliable person to testify whatsoever, bro. Not credible, attacking. Definitely got to have that on camera somewhere, somehow. The whole interaction is going to be on body cam. Okay, my bad. Sorry.
As established in International Shoe Co. versus Washington 326 U.S. 310 of 1945, personal jurisdiction cannot be established through unconstitutional means. Third, procedural jurisdiction is lacking because my court date and location were changed without proper written notice, violating fundamental due process requirements under the 14th Amendment and Article 1, Section 19 of North Carolina Constitution. I therefore move the court to address these jurisdictional challenges before proceeding further.
Damn.
Before we continue, right there, I guess the court date and location were not ever changed. That is just misinformation that the lawyer gave me. And the next day he gave me that misinformation, I went and requested the file from the clerk, and that's where I found out that my court was still in Siler City, and I did find out that it was a new date, but the location was still the same. So
Okay.
the lawyer gave me wrong information.
That's crazy. And then he wants you to sit there and keep him on the case and pay him. This nigga,
Yeah.
the audacity.
He's still rebutting my every point.
This guy's crazy. What is going on with this dude? He's tripping. Ugh.
Okay, I can no longer see the script.
All right. Let's see. Share. Okay.
Can we hear from the prosecutor?
Oh, sorry, Your Honor. The defendant was properly charged after being found in possession of a concealed weapon and stolen mail, and she resisted the officers during her lawful arrest.
Objection, Your Honor. The prosecutor's statement contains multiple unproven presumptions that I must address. First, I object to being referred to as the defendant. I am a living woman appearing specially to challenge jurisdiction, not a legal fiction or statutory person.
Hold on. Didn't Danny just say something about that? Danny, didn't you just say something about this, Danny?
That's good.
Danny.
I did. She's not the defendant. That's a presumption on their part. It's a rebut that shit.
Yeah, that's why Quinton, he's always like, on everything I want, defendant in there, defendant in there, defendant in there. Yeah. Okay, go ahead.
Okay. And second, I object to the presumption that I was properly charged. The charging documents fail to allege essential elements of each offense and lack verification by a first-hand witness or injured party. Third, I object to the presumption that the arrest was lawful. The deputies acted without reasonable suspicion or probable cause, based solely on allegations from an individual who assaulted me. Fourth, I object to the presumption that I resisted officers. As documented in my affidavit of facts and medical records, I was attempting to explain my physical disability and the pain being inflicted upon me, not willfully resisting. Fifth, I object to the presumption that the mail was stolen. I had no knowledge of its presence in my brother's backpack and had no intent to deprive anyone of property. Six, I object to the presumption that this court has established jurisdiction when that very issue is being challenged.
Yep.
These are not mere technical objections, Your Honor. They go to the heart of due process and the rule of law. The burden of proof rests with the state to establish each element of each offense beyond a reasonable doubt and to establish jurisdiction by competent evidence, not by presumption or assertion.
By competent evidence, not by presumption or assertion. They can't just say it. Bring forth your evidence. Oh, well, we have this charging information document. That's great. That's you saying it. Where's the evidence?
Now, is it okay that I'm going to be reading this? Because I have been studying this, but...
Oh, yeah, no, you're not a lawyer. You're not schooled in law. Everything that you say is supposed to be, I need the court to take judicial notice that everything that I'm stating here today must be taken and construed liberally. I don't know how all of this works, but I am attempting to defend myself in the most proper manner. I will not understand or stand under anything. I will only comprehend what is being reflected upon me. Then I will rebut all presumptions, leading all burden shifting onto the state for them to bring forth their claim without a reasonable doubt that my constitutional violations were not on the front end violated. The jurisdictional aspect is one thing, but if we need to go on from beyond that, the only other thing that will be spoken of from me on any matter here is the constitutional violations that have egregiously caused me irreparable harm. How can such egregious actions be taken against me in harm of a claim when I am innocent yet to be found guilty? That's not how this justice system works. And if you think that you got jurisdiction over me when all of these constitutional violations have happened on the forefront, you are mistakenly, grossly wrong in so many manners that I have to move it up to the next card above. You know, I'm going in on any aspect that I possibly can if I have to. If it really gets to where I get emotional and feel it because of the action so egregious. If I feel like I need to chill out for a little bit and just go through the process, which some people will be like, no, just end it there, bro. You sometimes you got to go through the process to get things done right. Why can't you just follow the real brick road and win? Like we have a judicial, thousands and millions of people died for us, really, truly, to have this judicial process, and you just shitting on it and pissing on it because you just want to. Like, I understand these assholes are assholes. Yes, they did wrongs. We're bringing it up. We're doing it the right way. We're filing civil suits and we're winning on the back end. Why does everybody think that all this bad shit that they've been getting, why do you think it's so big a deal that we start having shit change around in our whole judicial system again? Why do you think Chevron just got repealed? You dig what I'm saying? Like, administrative law judges have lost a lot of protections. As much as executive orders may be signed in, the judicial branch is the judicial branch. That executive is not going to override my constitutional rights, my creator endowed liberties, guarantees. It's never going to happen. You can never stop what the people have within. I'm breathing of the ether, which is God. You cannot tell me I am not part of God. You cannot tell me that I am to be administered, because if that's the case, then the administration in and of itself is repugnant to my freedom. There is no involuntary servitude that will happen here, good sir. I'm sorry. I am not that person. I am not that label, that title of nobility in which you seek to place upon me as though I am below or belittled by such title. My existence is of I am, just as much as we are. And there will be nothing that will ever encompass you or belittle you or put you into the aspect of being a genie. Are you a genie? I ain't getting trapped in no little motherfucking bottle. Excuse me. That is not.
Mr. Wilson,
Yes, sir. Excuse me. Sorry.
your arguments are excellent in behalf of representing Palmyra. However, it's my job here today to trample on your rights and deny you due process. And so we are going to continue these proceedings.
Yeah, looking, yeah.
Pretty much.
Right up. Well, let's get to it, Your Honor. I'm going to first off need a bill of particulars being ordered from the state immediately within the next 14 days before any other things are to move forward in relation to any kinds of pretrial hearings. First off, what I'm going to need is a jurisdictional hearing if you wanted to set one up. I'd be also open and willing to go ahead and look at a probable cause hearing. And you may say I don't need one, but there needs to be probable cause. And I know it's a low threshold as far as hanging fruit to be applied, but we still need to look at those so I think the court can understand a little bit more of the circumstances that are being that are present. The court here has already dismissed 2 of the cases and then changed, or excuse me, the DA has changed 2 of those cases into a lower situation as far as charges are concerned, and you can see that, and that is because of the egregious and illegal charges that have been brought forth in the first place. So, I mean, there's so many aspects that you can go into, but I think if you're keeping it cool, calm, and collect, and you just chilling and knowing that you have all eligibility to move the court, to get a continuance of time, to prepare for things that you need to file, you really just, you taking it chill. Everybody want to always hit on the constitutional or jurisdictional aspects, but I like to get in, I like to get in there and argue. You know what I'm saying? I'm gonna get in there and do a little bit of arguing, have some fun, call out the state a little bit if I have to, and they want to be an asshole. You dig what I'm talking about? And have a little bit of fun, because I know first off that I didn't do anything wrong. Once you release that, then it really makes it easy to say, you know, I'm gonna have a little fun because I know I got all these avenues. I know I got suppressions, I got motion for dismissals, I got reconsideration aspects, I got remands, I've got bill of particulars and statements, I've got writs I can do if I want to hit for interlocutory appeals ability, if I've got any bias or prejudice, I can hit for disqualifications. I got so many malicious prosecution. I mean, there's just a flurry of availabilities of avenues and roads you can turn down. So
Mr. Wilson, I don't know any judge in this country who could stand up to your excellent arguments. I'm going to go change my pants.
This guy, that boy walked off the bench.
No, his brown
he didn't
pants.
walk off. He changing jurisdictions on you.
Yeah, right then and there. There's so many different avenues. I mean, we haven't even gotten into the depths of the trust aspects and just applying those and you know, never arguing. But arguing is strengthening our people. Learning is strengthening our people, right? Developing is empowering our communities, our families again. It's giving true strength. I had a meeting with Jacob and his father. Jacob's, they had already paid, I think, like $7,500 to this attorney, dude, for a retainer. And I was just like, what, bro? I was like, bro, what, on a traffic ticket? He's like, yeah, man, I'm in Florida. They found dabs, bro. I'm like, what? I was like, wait a second. Well, they have a warrant to search the car? Like, and his dad comes in after like 30 minutes of the meeting, and his dad's pissed. And he's all like going off on me, and he's like questioning me, and he's so skeptical of me, bro. Because look at me. I mean, come on. Believe this guy here. Believe this guy. And dad was pissed, guy maybe ties, age, but just not the same mind frame. Totally opposite, And I had to sit there and like convince him and show him proof of what I've been doing for like 25 minutes, and then run him through another 15 minutes of explaining, just the depths of these things. And Jacob's only 22, and he came in a little bit nervous. But then you got Layla that's 22, and she's over here like, fuck this, standing on it, and the damn jail people are holding their face into the mug shots, huge lawsuit just for standing on her ground, right? And that strength that comes within comes from the great creator.
Mhm.
We all have that within us. It's
Yeah.
just knowing again that that's what you are. I
That
yield
last
this
one
way.
you mentioned. The last one you mentioned was totally messed up.
They grabbed the girl.
In the mugshot. Yeah, that was.
Yeah,
Well,
Layla.
this is
beyond
in
all
the
measure.
same realm. You got Palmira being shoved in the back of a cop car while she's literally pleading and trying to tell them, look, I'm in pain, I have a medical condition, please listen, stop. It's like I had to do the same thing with Schoenborn. He pushing me and pushing me and pushing me, and I'm like, bro, can you please stop? I have one leg. Please be respectful. Please be nice. Then they got me in the back of the cop car. My leg don't bend at a 90-degree angle like that, y'all. Like, without me taking it off, it's like pulling my skin internally, the sleeve,
Damn,
on my
dog.
knee. Like, that shit hurts so bad, bro. Like, it literally peels off layers of my skin when it's like that for just a period of time. Like, that amount of time definitely was killing me, bro. Like, it's beyond. They got no record. They don't care. It's like you're innocent until proven guilty, but it's like, okay, it's just like a whole ego thing on all of them.
Yes.
And
And
that
here is
Red
a
Bull.
small town, so everybody's like cousin to everybody in the law system.
and why? Why is it the blanket? And this is the thing I feel like. I'm not against law enforcement when it's properly applied.
Mm-hmm.
We need
Same.
law in our country, bro. Like,
When they're acting as peace officers, but when they're acting as police officers, now they're in the realm of the administrative prospect, the
Right.
administrative aspect.
Mm-hmm.
And we see too many times how the police have lost all empathy for their community.
Oh
They
yeah.
look at every blanket situation as the same. They disregard psychological issues. They disregard drug abuse substances, people who have those mental health issues in relation to that. They disregard those with disabilities. They disregard anybody who stands up on their creator and down rights, which, if anything, what happens with that is you have a belief. You have a belief in God, right? So if anyone is immediately standing up on their belief, let's just say like most recent Alira's, right? She's standing up on her beliefs, right? And standing up to, I don't have authority over me. You may be a policy enforcer, but you still don't have authority over me. And he said, to put down your window. She's like, yo, this fine enough to talk to you, bro. Well, I want it down more. Look, bro, it's cool where it's at. Quit trying to tell me what to do, my guy. You're not my boss. Let's get that straight. Oh, call and rate. Sovereign citizen. We got a sovereign citizen. So right then, what happens? That prejudice and bias right there creates a issue upon your belief, your knowing, your education. You believe in God and that no authority is over you, and they call you a sovereign citizen. Is that not prejudice and bias? Is that not an attack against your faith? Again, we don't see what it really is for. It's all irreparable harm. You like that? You might as well just say, if someone does that, you might as well, you can replace that. Oh, sovereign citizen, Christian. Oh, sovereign citizen, Muslim.
Mm-hmm.
Oh, sovereign citizen, African American, which is
Sir.
a crazy term in and of itself for me, unless you're really from Africa. But
Don't forget us crackers.
we got an illegal immigrant. Just replace it for anything.
Yeah.
They're calling
Discrimination,
me
period. Discrimination.
Period.
on all the paperwork. They're calling me a white woman, and they say that the girlfriend, she's Filipino, that she's the minority. I'm Mexican. I'm not a white. But they're saying that they on all the documentation says that I'm the white woman, which is really messed up that they do that, you know.
We're all family. We're all family, like dogs and cats. They don't see color.
And yeah, and it's not that just that they go like that, you know, they're trying to, so I'm not white, but yet they're using that
A label.
yeah, to like hit on that agenda, you know, of white on the white. Like that's so messed up.
Put you in a category.
Yeah.
All right, where you at, Ty? Go on ahead.
Yeah, I need to move forward with these proceedings.
Your Honor, with all due respect, I must note for the record that proceeding without establishing jurisdiction would constitute reversible error. I have submitted a verified affidavit of facts that stands unrebutted on the record under the doctrine of tacit procurationem. Silence equals acquiescence when a party has a duty to respond.
Yep.
The state has had ample opportunity to rebut my affidavit point by point, but has failed to do so.
Okay, pause.
That's a good one.
Y'all gotta understand this applies across the board to all things filed and never rebutted by the state in writing. Please understand that tacit acquiescence does apply into the courts. If you're filing something and they not responding, bro, that's totally not, they've acquiesced to it. You have a duty to respond, state. This is chess. This is court. This isn't just like I get to just keep moving and doing whatever I want. You must respond. You have a duty. You have to prove without a reasonable doubt. You have elements you must do. All right, go ahead.
Yes. I therefore move the court pursuant to its inherent authority to manage its proceedings and ensure due process to order the state to file a verified point-by-point response to my affidavit of facts within 10 calendar days.
Wow.
This would serve judicial economy by narrowing the issues in dispute and potentially resolving this matter without unnecessary litigation. Furthermore, I move the court to schedule a jurisdictional hearing pursuant to North Carolina General Statutes, subsection 15A-952 and subsection 15A-954, at which the state must present evidence establishing jurisdiction beyond mere assertion. The jurisdictional hearing should precede any substantive proceedings in this matter, as jurisdiction is a threshold issue that must be resolved before the court can exercise any authority over my person or the subject matter.
Now, do you see how these scripts may not be perfect, how each and every one of you may want your script to be, that you take into court? But do you see how the multitude of scripts allows one to comprehend what they need to bring forth to create their own, whether they copy and paste? Everybody is presenting themselves. You've got to present yourself in the way that you feel comfortable doing so. But the proper preparation allows one not to feel as though or comprehend the aspect of how much just power they have. And that's the main core of all this. With Ty, with everybody here, they can back you in knowing and showing that you truly have the power when you stand on it. You just have to know it.
Okay.
Your Honor, the state opposes any delay in these proceedings. The defendant was properly charged, and this court clearly has jurisdiction.
Your Honor, I object to the prosecutor's conclusory statements and move that they be stricken from the record. The prosecutor has presented no evidence, only assertions. I remind the court that pursuant to North Carolina General Statutes, subsection 15A-954A8, the court must dismiss the charges if it determines that it has no jurisdiction over the offense charged. I am entitled to a hearing on this jurisdictional challenge as a matter of constitutional right. The Sixth Amendment to the United States Constitution and Article 1, Section 23 of the
Wait.
North Carolina.
This one right here is, you know how I like to say we had open as a matter of right for public vehicular travel? That, as a matter of constitutional right, we need to start saying that more. As a matter of constitutional right.
Okay.
Just like we have open, the public roads are open as a matter of public right. Yo, man, this is a matter of constitutional right here, man. Like, move around with all that mumbo jumbo statutory deprivation of law, color of law talk. Hey, this is open as a matter of right, bro.
What about natural right?
Yeah, that too. But, you're bound by this. This is open as a matter of right. This is all about a matter of right, especially a constitutional one that you're bound to oppose. So move around with that, clown. Like, I understand mine. I understand who I am. Don't even talk to me like that. We're not even gonna go there. All right, my bad.
Okay.
You were talking to me?
Yeah, I was talking to you. If you the cop, police.
I thought you said Lynn. I'm like, damn, what did I do? Never mind. Go ahead.
Okay, I am entitled to a hearing on jurisdictional challenge as a matter of constitutional right. The Sixth Amendment to the United States Constitution and Article 1, Section 23 of the North Carolina Constitution guarantee the right to be informed of the nature and cause of the accusation. This right is meaningless if the court proceeds without establishing its jurisdiction to hear the matter. Additionally, I move for a probable cause hearing pursuant to North Carolina General Statutes, subsection 15A-606. The state must establish probable cause for each element.
Demand or waiver of probable cause hearing. If a defendant is charged with a criminal offense within the original jurisdiction of the superior court, the judge must schedule a probable cause hearing unless the defendant waives in writing the defendant's right to such a hearing. Uh-oh.
Oh.
Uh-oh. This is not for debate. This isn't a matter of if it's a felony or not. Like Quinton just had to go through. Do you understand? This is not a debate. It must occur. It's a right. Open, it's a matter of right. What are we not understanding about this shit? Once we start demanding things, it must take place. The court works for us. Stop thinking they run you. Yes, ma'am. No, it's not Sunday. It's Saturday. It come tomorrow now. So do you see what I'm saying? A defendant represented by counsel. Okay, we ain't worried about that. Evidence of a demand. Hold on, girl. Evidence of a demand or waiver of probable cause hearing may not be admitted at trial. If the defendant waives a probable cause hearing, the district court judge must bind the defendant over to the superior court for further proceedings in accordance with this chapter. If the defendant does not waive a probable cause hearing, the district judge must schedule a hearing not later than 15 working days following the initial appearance before the district court judge. If no session of the district court is scheduled in the county within 15 working days, the hearing must be scheduled for the first day of the next session. The hearing may not be scheduled sooner than 5 working days following such initial appearance without the consent of the defendant and the prosecutor, both. If an unrepresented defendant, because you're represented. If after the first appearance before the district court judge, a defendant with consent of... Now, let me ask you this. Did you already make your first appearance, Palmira?
No.
Okay. No. Yeah, so you already
Not
know.
for, yeah, no. The time I went to court, it was for the restriction order that I had placed against the girlfriend, and she had placed one against me right after. So it was just dismissed because we reconciled. or we just both dropped them, decided to drop them. But no, not for the criminal. I have not. They just moved they changed the court date. Yeah.
Yeah. Okay. Well, does anybody else have anything else they want to say currently right now? I got to take just a quick break. Just kind of like fill it real quick, if you don't mind.
Dad first.
Okay.
Yeah, the second one's pretty cool.
It's
I
better,
like the
right?
second one. Yeah, because it's more on constitutional grounds. As Panawal Downing said, have the high ground, right? The Constitution is the high ground. The second one was great as well. The first one was great also because it went up the ladder from the statutes, the code, and then it went into Constitution.
I love how you're standing on your square, though. You stay there. You keep staying there and force them to just move on without you.
Okay.
You know, and at the end of each thing, you reserve all your rights. I make a full reservation of my rights. I've waived nothing. I mean, you're saying that in your own words.
Ms. Stevens, you understand that I'm here to lie, cheat, steal, and deprive you of your rights. Is that correct?
Yeah, I comprehend that.
And are you going to allow me to do that?
I reserve all my rights and
Waive none.
and I waive none.
Waive none.
But I don't give you power and authority to do that. I have jurisdiction over you.
It is the burden of the prosecution to prove that on the record with admissible evidence.
Good job.
Honey, I just want to say you're going to do great. Just keep calm, wear something nice, professional. I mean, you're studying, you've got this. I don't know how long you've been studying this whole thing for, but you're doing great and you're going to be awesome in there. I can't wait to hear all the good news.
How long has it been? How long have you been doing this?
Like 2 weeks,
think so,
really.
2
weeks.
2 weeks and you're that
I mean,
good? Wow.
I've been into learning about this for a while now. I've always been interested in natural law, and even the day they arrested me, I was just like pissed off. Like I couldn't understand why the officer was arresting me. So I started just saying, I'm a natural woman of this natural earth, and
Do you believe in the
you
Bible?
can't do this to me, you know.
Do you read the Bible? Do you believe in the Creator?
Yes, I take Bible studies. I'm currently doing that.
Okay.
I have the
Okay.
Bible.
So go with Jesus. What he said. Have no fear.
Yes,
You go in there.
365 times he says
Yep.
that.
Leave. That's right. Leave that fear out because that's what they run off of. That's the fuel that feeds the fire.
Yes, it's true.
Fear,
Yeah.
fear not,
Yeah.
for you fear not. I have called you by name. You are mine.
Thank you. Yes.
On the conclusion of everything, right? Of everything that we've gone through today, through these scripts and through what she's about to go through, on the conclusion of the initial hearing, we've noticed and seen what we came into through Quinton's, right? We've seen what Quinton went through and how his initial appearance went. And we're seeing the differences between how his went and how we're trying to get Palmira's, correct? So first off is to maintain a special appearance for the limited purpose of challenging jurisdiction, objecting to presumptions made by the state or even the court in and of itself, insisting on proof of jurisdiction, again, once we challenge that bad boy, request a written response to the affidavit of facts, and because we haven't filed our notice and demand yet,
Not yet.
move for jurisdictional and probable cause hearings, preserve all issues for potential appellate review, and remain respectful while firmly knowing that you're going to be able to assert all of your rights as a creation of the Creator. Keeping that notice in demand, if we need to and we want to, we can file that notice in demand as unconstitutionally applied right there in open court.
So don't file it on Monday then, before the court date.
Oh, you can. Oh, you can if you want to. That's totally
You
up to you.
should.
I should.
Everybody was
Yeah,
saying go ahead, throw it in
I'd say
ASAP,
so.
so go ahead. Go ahead.
All
I'll let
right.
the court talk for me on this one.
Well, because Cam thinks I should just hold on to it, and if I need to, file it in open court. But
why I like it, because it might tip
How
your
will
hands
I
a
know
little
if I
bit.
need to there?
Well,
Like,
because what's going on is, look, this is what's going to happen. The affidavit's already out, right? Okay, now you got an affidavit. They're supposed to respond to that bad boy. Okay, and you're requesting a response to that. If you know that both of those are there and you're not going to really have a chance to talk about what you want to talk about, they're going to try and limit it. What I would say is call for a hearing, both jurisdictional and probable cause, like we said, and then also go ahead and file that in open court so that, hey, I would like to file this notice in demand as well as unconstitutionally applied. At least these statutes are concerned. And I'd like to see that the court go ahead and order a response both to the affidavit and this notice in demand. And by
I like that
verbally,
too. I love it.
yeah, by verbally stating it, now you're getting a conversation going in there. First off, you're feeling good about yourself that you can come in here and do this. That's number one. Then number two, you're showing that who has the power here, right? Who has the power here? I'm throwing again, the burden is being shifted, not just verbally now, but through documentation on both the court and the state. Again, let it reflect on the record. Let it be known on the record. May it please the court that I have already filed an affidavit that has gone unrebutted at this time and would like to see a response or an order from the court to have the state go ahead and fill that request and its duty to respond to that. If not, of course, it's going to be tacit acquiescence to every statement that I have made therein. And today in open court, I'm going to be also filing a notice in demand as unconstitutionally applied, at least how the statutes are applied. And the reason being is because there are some major serious constitutional violations that have been that are at the forefront in relation to the application thereof of these charges and claims that have been brought forth. And again, I'm not waiving any of my rights whatsoever, but I do need to bring this to the court's attention here today.
okay, so Sean says if you file ahead of time, it's already on the record. In open court, the judge can dismiss it outright.
Well, the thing is again, rebutting that and requiring the burden to be shifted to the state. It's not the court's duty to rebut everything that's being brought forth. Like they brought forth a claim, they need to rebut that shit, right?
Yes, and burden.
It's burden shifting all day, man. But you got to also remember, you also have a reconsideration. You can always file reconsiderations, right? And to make sure that they give a written determination on any dismissal. So if, like Sean's saying, well, the judge can dismiss outright. Well, he's got actually duties to respond to that bad boy, okay? You can't just say I dismiss and then not give a response and then, hey, I come through with a reconsideration and you, again, don't respond properly like you're supposed to according to the rules. Guess what? That's going right up to mandamus, and then we're doing an emergency stay on any proceedings pending the appeal or decision from the higher court. And that's how that goes.
For any reason, they made me sign like a plea or something. I can sign under duress, right under my name or next to it, and coercion.
UCC 1-308.
Okay, just write that.
Yeah.
Okay.
Or you could write the North Carolina equivalent.
I don't even sign my name. I just act like I'm signing my name and put under duress, or like on my ID. The only thing it says on my ID card is Agent 4.
So y'all's is just North Carolina General Statutes, Chapter 25, subsection 25-1308.
Okay.
But without prejudice or under protest or the like are sufficient. Okay? Right there.
Without recourse.
Under protest. Well, specifically for North Carolina, if she puts under protest, she good. She good. Oh, y'all weren't seeing my screen. Sorry. Here, let me show you.
Okay.
This one. Yeah, North Carolina General Statutes, Chapter 25, Uniform Commercial Code, subsection 25-1308, performance of rights under acceptance of reservation of rights. Such words as without prejudice and under protest or the like are sufficient.
Gotcha. Thank you.
Yeah. Subsection B of this section does not apply to an accord and satisfaction. That's for another meeting, though. Palmira, how did you enjoy today?
It was great. Thank you all for helping me with this and practice with the script. I find it very helpful. Yes. You guys answered many questions, and most of all, it gives me confidence, the confidence that I need as well. Yeah.
I got something to that. You know about etymology?
The
Breaking
dictionary.
down of words?
Yes.
Etymology, breaking down of words?
Oh, no.
Well, here's one for you. Mexican. There you go. You can.
Yes.
Comes back to the Mexica, honestly. If you think about and understand where that even comes from, it's because the Mexica, it's just the Mesheks. It's
Thank you.
yeah, it goes very deep, Like that's why I say like Mexico, America is Mexico. Like the depths there,
The Gulf of America.
the depths there. I mean, yeah, the depths are crazy, America's got some really amazing historical values to the whole society.
Isn't America's like an Italian lady's name though?
No, it comes from to marry or amake mekan. Okay, there's it predates everything, bro. Real talk.
Gotcha. I was just wondering.
Yeah, amake mekan. Okay, watch out, bro. This is Huehuetaplan. You dig what I'm talking about? It's Nahuatl land, man. Like what?
So my brother's one of those geniuses. He's like, you need to get all these Mexicans out of America. And I'm like, aren't we in the Americas?
Isn't Mexico America? I thought Mexico was America, if I'm not mistaken. So, yeah.
Okay.
Everybody, what y'all got to say to Palmira? Y'all got to say anything to Palmira before we close out YouTube?
I think you're going to do really good. You stand on your square, and remember, we're all going to be watching. Everyone's over your shoulder. You got God on your side, sister.
Yes, thank you, Daniel.
2 weeks and you're this good. I'm proud of you.
Oh, thank you very much.
Use that fear to pull you over your challenges.
Isn't this proof of the 100th monkey syndrome? Like we keep putting it out in the world and ringing that bell inside of the consciousness field. And then ultimately, sooner or later, kids are going to be born just knowing this, just like the 100th monkey syndrome. I think we're approaching that.
I agree with that. Yes. So
Get rid of the fear.
Better the race by upgrading the consciousness. Yes.
Yes, ma'am.
Fear, right? Fear fuels the machine. Like that. What is that cartoon? Monkeys? Not monkeys. What I say? Monsters Inc.
Oh,
If you ever seen that cartoon?
Mm-hmm.
The
Yes,
fear
I'm familiar.
fuels the machine.
Right.
Yeah, that's true. Mm-hmm.
And even if they call you a white girl, if Mexicans, Americans can too.
Yes. Yeah, I don't find it offensive.
American.
I just notice what they're doing,
They're trying
They gonna
anything
push
they
them
can do to
buttons.
throw you off your square.
Oh
Yeah.
yeah, because if you ever been in jail, that's what they do. They sit there and just keep poking you and poking you and poking you until you flip out. And they're like, "Look, he needs to be locked up, insane asylum.
No.
He needs this. He needs medications. You know what I'm saying? Trust me, been there."
For everybody else, did y'all find anything today in these scripts kind of helpful?
Almost all of it, Cam.
Great.
This kind of role playing
Yeah,
is necessary.
Yeah, more role playing is necessary, for sure.
the first script
It's the
was great.
juice, baby.
Y'all did good on that, though. I'll give you credit.
To
That
be able
was
to
really
practice
good.
out loud is a freaking awesome standpoint.
Yeah,
I think we should do that more often, in my opinion.
much better than practicing on the mirror.
Yeah.
But the mirror's the best
Yeah.
one because you're looking back at yourself.
Y'all did good though. That was impressed me. I think you should do that more often so people can get used to it before they go in there.
Well, I had to do something crazy for Who was this for the other day? I did one that was pretty badass. It had
Yeah, I'm
3.
glad I didn't see that naked
Oh,
guy.
that was Hayden. That was
I was in
Hayden.
the chat.
Lynn.
Oh, I have
Cameron,
not seen
Cam's
that.
like, I gotta go. I didn't
Yeah,
see it either, but
yeah, I didn't
Cameron's
either.
like, I need a
Dude,
minute.
please tell me
I
that
gotta
wasn't
go.
me, man.
He's like, I need a
No,
minute.
no, it wasn't you. But I just the other day or yesterday, I guess, last modified, I made a pretty comprehensive 3-part courtroom advocacy script for Hayden's next hearing. So if you know, I think it's in his Discord, but this one's really, 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 really long. And it gives 3 different aspects on how the judge might approach it or how the situation may go. And so we gave 3 different scenarios. That way he could just be prepared for any way that it may turn out. But we actually made the ways, or should I say, the hypothetical situations to play out like we wanted, right? So getting that feel for each 3 of these situations as far as how we think the judge might operate and act really is making Hayden a lot more prepared. And yesterday we went pretty heavy on just doing developing, going through these things, through the authoritative approach or more of a laid back approach, or what was the last one? I wanted to see, or a victim approach, right, for officer misconduct in relation to the Rodriguez violations. So it's really just no matter where we are in our sections as far as our cases are concerned, we're always still developing hypotheticals to make sure that we're properly prepared, like any attorney normally would. I think any normal attorney is going to go in with proper notes prepped out with proper cases that they've learned and what they're going to hit for on the most. I feel like the only thing that maybe attorneys lacked in the past is actually verbatimly actually reading some things, because they just rely on, oh, I'm just so smart that I'm just going to read, know it in my mind. Bro, I ain't got time for all that. Me personally, I'm going to read because I just don't have time. And it's efficient for me to read. If I know what I need to bring forward, I'm gonna read it into the record, bro. Nobody's going to stop me from doing that because I can present myself how I want to. So, and they must take the time because you have a right to be heard.
That's probably what I will do.
I
Yeah, I
think
do.
Hayden's about got it down packed where he can almost be a lawyer.
Well, he's doing good for himself for sure, but he still be getting nervous. He still don't be knowing where he going in some aspects, and it's really just
But
doing
he's
research.
getting there.
In everybody's situation, everybody's state's a little bit different and operates a little bit different, but
True that.
and then everybody's level of patience and everybody's level of confidence, it sways, I think. He got an order and really didn't understand that order, and we went through the order a little bit more, and we started to understand, bro, you literally got about 30 minutes of footage that cannot be submitted into the court. Like the state really has nothing against you if you really think about it. And so once he got to really understanding that order again, because he was reading it incorrectly, that confidence built back up. But he had been stressed out for this whole past week because of that. You see what I'm saying? So it's like, bro, you just read it wrong, bro. Like, what are you doing? You know what I'm saying? So it's just maintaining that peace within yourself. And because again, you didn't harm anybody. So what you stressed out for? Nothing's gonna happen to you, bro. So
It
yeah.
really does help to remember that. Yeah. It's like just yesterday my brother called me and said, "Hey, just letting you know that they moved my court to your location too on the same day." He's like, "But I'm really worried about you. Everybody says that they're very strict there." And I'm just like, don't call me to tell me you're worried about me.
For real.
Just like leave that, like just don't call me to tell me that. I'm
Yeah.
not worried. And I said, I didn't commit a crime. I didn't do anything. Just don't worry.
Yeah. That's how they win, is that's all based on fear. That's it. And it's all from want of jurisdiction. It's all in your own mind. It's crazy. I don't see how it's gotten this far, but it's pretty wild. All right. Well, that's
It
the
is
end of
crazy.
YouTube on this one. I'm gonna keep it going on the stream. But as far as YouTube, everybody unmute and say bye for YouTube.
Bye, YouTube.
Love
Bye,
YouTube. Love you guys.
YouTube.
Bye, YouTube.
Bye.
YouTube.
Quit shadow banning.